$26 billion in 1 month. That's the trading volume on prediction markets in just April of 2026. 26 billion in 1 month. Many believe prediction markets are this new and novel business, which were started by projects like Kalshi or Polymarket. You might even think that too, but that's wrong. You're off by about 600 years. Prediction markets are not new. They've been around longer than the United States has existed as a country. They're older than things like steam engines or even champagne. I spent over 100 hours putting this one podcast together. My goal is to take you, even if you've never heard of prediction markets, to a 99th percentile understanding of what they are, how they work, understand the history behind them, the regulation, problems, and the futures of these markets. And I've spoke with many leading experts to do that. But how old are prediction markets really? Well, the National Bureau of Economic Research traced the history of prediction markets over 500 years across the Atlantic Ocean to 15th century Italy. Those Italians bet religiously on papal elections. I hope you appreciated and caught that pun. I couldn't help myself. As well as political elections. By 1503, betting on the next pope was already considered to be an old practice. Bets on these prediction markets weren't limited to the choice of pope either. 15th century Italians would also try to predict related events like when the conclave would end or how long the new pope would reign. This popular practice continued until March 1591, when Pope Gregory XIV banned all betting on papal elections, the length of papal reigns, or the creation of cardinals. And why did he do that? Well, here's Koleman Strumpf, an economics professor at Wake Forest, who wrote the definitive paper on the history here and has been teaching courses on prediction markets since 2008. He explains what Pope Gregory XIV was first opposed to, and it kind of makes sense.
Take yourself back to the 16th century. The Pope was a much bigger figure than he is today. I mean, he has the direct connection to God. And anything that in any way denigrates the Pope would be something that's pretty bad. So, for example, one of the first things that Paul and I saw the Pope be opposed to were these markets on, will we have a new Pope next year? Which basically means you're betting on death. And that's not, if you're talking about the guy who's talking to God, that's probably not so good to be betting on that.
But despite Pope Gregory's efforts, the demand for prediction markets didn't end there, of course. It merely pushed the practice underground, which made it more opaque and dangerous for everyone participating. That concept is exactly what happens when regulations push businesses offshore in modern America. So instead of yelling to ban prediction markets, I've spent 2 months and over 100 hours making this podcast so that we can have a thoughtful and informed understanding of where the risks are and how to address them. Because prediction markets are important, and I'm not alone in thinking that. Here's Koleman, again, who graduated with an economics degree from MIT, on the societal importance of prediction markets, even for those who never place a bet on them.
So there's at least 2 or 3 things that I think, from a societal perspective that are favorable. For people who don't trade in the markets, which I would include myself among those people, because I've learned I don't have an edge against people. Like, I've talked to a lot of traders and they're much smarter than I am. So I'm not going to beat these people, but I can still go to Kalshi, Polymarket, or whatever site you want to pick. And I can draft on all the forecasts that these people are generating with their trades. And I can learn a ton about the world, whether that's about foreign affairs, economic indicators, elections. It's pretty amazing. And to me, it's like first step in my sort of a news diet for the day. Go to the prediction markets, see the stuff that's bubbling up, use that as a way of informing what I read in the news. And oftentimes, like, we're not quite at the point where the newspapers, in my opinion, are so disciplined by this stuff. So they write a lot of articles they'll say something about an election and say, oh, this is a close election. And then you go to the market and it's like, oh, that candidate's 75% likely to win. I skip that article because I trust the markets over a reporter's vibes. And anyway, maybe someday that'll change. We'll see. So that's one thing. The other thing, of course, is like for the traders, the people who are trading in the market, this is a way of, it's sort of another venue for people who have smarts to use those smarts as a way of making money. I think the bigger advantage, which we're not quite at yet, but there's been discussion of recently, is the possibility of using these markets for hedging or insurance. Yeah. And then the idea here would be once these markets are really liquid, people can, go to the market and potentially insure against downside risk. You can have these markets allowing people to hedge on, if I own my house, I do own my house. Suppose I want to sell my house, but I want to sell my house next year. I want to lock in a price, kind of like, farmers lock in prices with futures markets. I can use a prediction market if there's one, say, on a metro area to help, minimize downside risk for price movement. So regular people, big companies, all of that I think is potential. We're not there. I don't think we're there yet on that. The last thing I'll say is when I said long-term and like sort of in this long-winded answer I'm giving, we're also at a sort of a point where we're working through the problems of prediction markets, as you've already said, things like insiders and things like that. And it's kind of like saying, if you went to the stock market in 1931 and you see a lot of big, there's a lot of bad stuff going on in the stock, or go back in the 1920s and bucket shops and all sorts of crazy stuff going on. You could make a conclusion that says this is just not a good way of allocating capital across our economy. We should shut down this market. Or you could say, maybe we want to regulate this and sort of, tamp down some of the bad stuff, and hopefully the good stuff will rise up later. And I think we're kind of in that stage right now with these markets.
Now, as I mentioned earlier, by the end of this podcast, even if you've never heard of prediction markets, even if you're not a lawyer, never want to be a lawyer, you'll be in the 99th percentile for understanding these. I promise you. Now, throughout this podcast, I'm joined by 10 plus experts like Koleman to cover the history of these markets, to explain the operational differences between sports books and prediction markets, as well as to share the latest on the ongoing legal battles that we see across America. We'll also look into some proposed rules from the future and speak to someone who works at the CFTC. You'll hear from the leading experts at prediction market companies like Kalshi, from legal experts at top firms like Cahill, as well as the lawyers who regulate prediction markets at the CFTC, and from various critics of prediction markets, because you're too smart as a listener for me just to present one side of the argument. We're going to hear both sides here. Now, for those of you who are new, welcome to the Law of Code podcast. My name is Jacob Robinson. I'm a former securities regulatory lawyer with legal degrees in both the US and Canada. This podcast is part of my mission to help people understand the legal layer of emerging tech so that we can live in a world with transparent and well-understood rules that are applied fairly to all. Think of it like the Huberman Lab meets the Acquired podcast meets Hardcore History, but for law. Now, if you want to help support this mission, please just take 2 minutes to share this podcast and subscribe. That's as YouTuber-y as I'm going to get, I promise. Because you're here to learn about prediction markets and not here to listen to me plug a podcast. And that's okay, because all I want to do is talk about prediction markets today. Italy wasn't the only country that had this long, thriving prediction market economy. Political betting in the UK dates back to at least the 18th century, when people were betting on things like elections, legislation passing, and even the status of the American Revolution. These predictions were made in private gentlemen's clubs and public coffee houses, as well as down by the docks. One of those public coffee houses, which was Jonathan's Coffee House, eventually became the London Stock Exchange. There's some cool little trivia for people like me who appreciate that. Now, this type of prediction betting arrived in the United States alongside early North American settlers. The practice on wagering on election outcomes in America is actually nearly as old as the country itself. It was a practice in the early days that was encouraged by politicians who asked their supporters to make bets publicly, since these would signal confidence in the candidates' chances and persuade others to vote similarly. People would make these bets, right? And they would say, okay, I'm betting on this candidate. And then they would use that public bet as a way or sort of as a justification for promoting that candidate elsewhere. Now, as the National Bureau of Economic Research's paper explains, since the economic incentives made these markets such a reliable source of information on future election outcomes, the main form of media at the time, newspapers, were at the heart of much of the early betting activity, with New York's main newspapers, including the New York Times, covering these markets daily. Yes, the New York Times was covering prediction markets daily back in the 1880s, all the way up to early 20th century. For example, in a 1924 story, the Wall Street Journal published a story explaining the work that prediction market firms did to consolidate knowledge. Quote, "The betting firms maintain a statistical department for the benefit of their customers and also have a man present at the principal speeches made by the candidates. This man makes unbiased reports of the psychological reactions to the audience, unquotes. That same year, 1924, it sure sounds like the New York Times was endorsing prediction markets with this line in the newspaper, quote, "These Wall Street odds represent the consensus of a large body of extremely impartial opinion that talks with money," unquote. So basically what they're saying is prediction markets work. There's this unbiased, invaluable opinion being shared publicly. But unlike today's prediction markets, which are licensed by a government regulator and must follow certain rules that I'll explain later in the podcast, there was little regulatory oversight over election betting in the 1800s and early 20th century, which obviously isn't good. One example of what happened, ahead of the 1832 election, the New York Attorney General, who was the son of the Vice President of the United States at the time, placed over 100 bets on the upcoming election. Can you imagine that? And they weren't alone. As Koleman Strumpf and his co-authors shared in their paper, it was reported in early 1840 that, quote, "some heavy bets were made between members of the House on the approaching presidential election," unquote. Obviously, we don't want members of the House betting on elections that they're involved in, considering they could just drop out at any time. Probably not the right thing. Now, ready for the good news? That type of activity is exactly the type that isn't allowed on regulated prediction markets today. Yes, despite what you might have heard, these markets actually have rules that are being enforced, or at least the ones that are regulated in the US do. I spoke to the head of enforcement at Kalshi. For those unfamiliar, Kalshi is a US-based prediction market, that platform that is regulated federally, about what happened when they found evidence of politicians using prediction markets. That's Robert or Bobby DeNault, who is also a lifelong Eagles fan. I know what you're thinking, Eagles fans, but I promise they're actually a lot better than people realize, and Bobby's a great guy. Bobby DeNault, the head of enforcement at Kalshi, is going to share his comments next after a brief legal disclaimer that officially kicks off this podcast.
Anything mentioned in this episode by Jacob Robinson or his guest is not legal advice or investment advice. All opinions are Jacob's and his guests alone. This show is solely for information and entertainment purposes only. Jacob and his guests are not your lawyers, nor are they investment advisors.
A reminder, we're about to hear from Bobby DeNault. He's the head of enforcement at prediction market platform Kalshi, to explain what happens when politicians in the US try to profit from their own information regarding elections on the Kalshi platform. I'll just note that when he refers to strikes and yes and no bets, he just means placing a prediction. Here's my question to Bobby as well as Bobby's answer. I think it was 3 different candidates, 2 Democrats, 1 Republican, were trading on markets involving either their own campaign or related campaigns, somewhere they had information. Kalshi caught them. There was enforcement action taken. Can you talk about what happened and how you caught them?
Facts at a high level. On our platform, we have rules about insider trading and improper influence of markets and affiliated source trading. And all 3 fit into this potential insider bucket at a broad sense. But the third is a broader prohibition on any trading by any person who is able to directly or indirectly uniquely influence the outcome of the contract. And it's really that third provision, plus some terms that we have for each individual contract listed on the exchange that have its own, hey, if you're in the sense of politics, a candidate, a campaign staffer, a pollster with a connection to a campaign, et cetera, you're prohibited from trading. It's that last influence prohibition plus the unique politics contract terms that prohibit candidates from trading on their own elections. And the reason for that is you can imagine an easy context whereby a candidate can place either no wagers on their own election and then, drop out and they get a windfall. But even yes trades on their own behalf, knowing maybe that an opponent is about to have some opposition research that they've done come out and their price is likely to go up. It's such a high risk, and the ability to influence exists uniquely with candidates that they're prohibited from trading on themselves. And one of the first projects we implemented this year was to impose some name matching tools so that any person who had boarded the exchange, onboarded with KYC, would be prohibited from trading in strikes that matched their name. And in doing so, we generated a few hits on candidates who had traded on their own candidacies. And so the 3 cases that you talked about all were the genesis of implementing that new solution. So going forward, by and large, candidates are blocked from placing trades on their own campaigns, which is great. And for these candidates, most of the ones we've worked with and spoke to who were generated in these alerts have largely been like pretty contritious. And if they didn't get familiar with the rule book, they took ownership of doing so and saying, I didn't look at the rules. I didn't check whether I was prohibited. I did see that there were rules, but I didn't, really closely examine it. And I accept responsibility here. Let me pay this fine and, we'll resolve it that way. These exchange disciplinary actions sit in this universe where it may not rise to the level of illegality. It may not rise to the level of something the CFTC should really be charged with policing. This is an exchange that cares about market integrity, which I think prediction markets uniquely not only should, but kind of have to from a business perspective, because you're not going to draw people to use these markets forever if there's not an expectation that they're getting a fair shake.
I'm so glad Bobby mentioned that last point, because prediction markets are businesses at the end of the day, and businesses need customers to survive. So if prediction markets were filled with insider trading, then people will simply abandon them, or laws will be created to ban them. Now, election betting isn't the only example of insider trading that a prediction market like Kalshi tries to stop. There's also people at businesses using insider information to profit on today's prediction market. Thankfully, we have rules for that as well. For example, if someone at Google used their insider knowledge of who the most searched people are that year to profit on a prediction market, they would be charged with a crime. Now, that's not just a hypothetical. That's exactly what happened. Here's Sam Enzer, a litigation partner at the law firm Cahill, Gordon and Reindel, who is also the co-chair of Cahill Next, Cahill's digital assets focus group, to explain the facts of that situation. And I shouldn't say facts, I should say the allegations. Thank you, Sam, for that point.
Allegations by the U.S. Attorney's Office for the Southern District of New York, which is the premier federal prosecutor's office in the United States. It's the Navy SEALs of the Justice Department, and I'm proud to say I used to be a federal prosecutor there. Anyway, they have alleged that Spagnuolo, who was a Google employee, that he had access to inside information, confidential data on what the top 5 search results would be for the year of 2025. And there were markets on Polymarket, the prediction market, where you could bet on, is Jimmy Kimmel going to be one of the top 5? Is the Pope going to be one of the top 5 Google results? And so he allegedly placed trades with access to that information, benefiting from that inside information, and was able to profit to the tune of over $1 million based on the trade, according to the charging document filed by the Southern District last week. And so they've charged him with, colloquially, we call it insider trading, but the formal charges are commodities fraud, misappropriating business information and using it to place a trade in the commodities markets, wire fraud, and a money laundering charge for taking steps to conceal the proceeds of the alleged insider trading.
Now, you've just heard from Sam Enzer, a partner at Cahill, Gordon and Reindel LLP, firm that helps make this podcast possible by sponsoring Law of Code. Since launching this podcast over 200 episodes ago, I've had the privilege of interviewing and getting to know Sam and the co-chair of Cahill Next's practice group, Lewis Cohen. Since launch, Cahill Next has been recognized by Chambers as among the most elite Band 1 firms in fintech, blockchain, and cryptocurrency. And I'll never forget the first time I met Lewis at a conference. I saw him holding the thickest binder you'll ever see. It was a printed, hand-marked up draft of proposed crypto legislation. You really don't see that too often these days. And it really put a big impression on me in terms of how hard these guys work. I always make a point now to keep an eye out for anything Lewis or the Cahill Next team publishes. They have these client alerts, which I read and I actually cite often in this episode. You can sign up for those via the link in the show notes. It's free to sign up. It's really an invaluable source of information. But, rather than just sponsor the episode, Cahill also adds value to the podcast by sharing the expertise of the highly ranked lawyers at the firm like Sam. I'm really grateful for them. And if you want to understand how the facts of your situation apply to anything we discuss in this podcast, you can get in contact with the Cahill team at mtomsky@cahill.com. That's MTOMSKY@cahill.com. I'll put a link in the show notes as well. Anyways, Sam made a crucial point here, and maybe you caught it. When people use the phrase insider trading, they're describing a category of conduct. Someone with confidential information about a future outcome that uses that information to take a financial position before the information becomes public, profiting from the resulting price movement, and usually violating a duty to whoever owned that information, in this case, Google. Insider information can be a very subjective term and a difficult one to outline for prediction markets, considering they host contracts for yes and no outcomes over a wide-ranging scope of questions, like will it rain in Arizona this week, to who will win the 2028 election, to which musician has the most streams in 2026. Got to be Drake after that album, right? Anyways, this is one of the really interesting questions facing prediction markets. And my goal with this podcast is to take you more in depth than any other resource on the internet. And I've checked them all. And so I'm confidently saying that. Now, here's Sam Enzer of Cahill and Cahill Next, again, to preview some of the big questions here, starting with the insider trading ones.
It seems like a simple concept, but when you drill down on whether something was an illegal versus a legal trade on information or alpha, it is actually quite difficult. And there's a reason lawyers have a job, which is sorting through the ambiguity and the complexity around it. For the prediction markets, this is a new frontier in several respects. So first of all, one issue here is the instrument. Is it a commodity? The government is taking the position that the asset traded was a swap. The state government is taking the position in trying to regulate sports betting and prediction market activity, that is actually gambling activity subject to a state license. And so right off the bat, we have a question about who's right about that question. Another issue is, in the context of prediction markets, when you're talking about taking a position, insider trading in stock, that framework is, the archetypical situation is you have an executive, a CEO or CFO. They know, let's say, the earnings that the company is going to announce in their SEC filing. They take a stock position with the benefit of that information and then profit after the announcement. But in the world of prediction markets, the types of trades you can make are much more varied. So, for example, there are allegations in the news that former Congressman Santos profited from trading on a prediction market about whether or not he would attend the president's State of the Union. Now, in that scenario, traditional insider trading law criminalizes when somebody steals information from the source of the information and then uses it to profit through a trade. But if you are the source, if you are using information that you are the very source of, that doesn't really fit in the insider trading rubric. So prediction markets open up this other area where you actually might be able to profit from something you can control the outcome of. Is that insider trading? Is that market manipulation? What is that activity? Is it regulated? Is it illegal? And then a whole other thing is, particularly in this Google case, you've got a situation where the trader was a foreign citizen and the activity happened offshore. So we're now talking about the extraterritorial application of the U.S. Commodity Exchange Act, the wire fraud statute, the money laundering laws. Do they apply to offshore conduct? Does the Southern District of New York have venue? They would say they do because the market, poly market, is based in New York. But that's a debatable query. So there's all kinds of questions in that particular litigation.
As Sam says, this is Rule 180.1. This is the first major application of that rule, which is one of the many big questions Sam hits here, though there are still more. Now, Rule 180.1 is what gives prosecutors a hook for prediction market insider trading cases. In the Spagnolo case, the Southern District of New York couldn't charge insider trading because there is no standalone federal insider trading statute that works here. But they could charge commodities fraud under Rule 180.1 on the misappropriation theory that Spagnolo breached a duty to Google by trading on confidential information. That, combined with wire fraud and money laundering, formed the indictment here. Now, this is one of the first major applications of this rule to a prediction market context specifically. It has been used in other commodities market manipulation cases before, but applying this to event contracts on a designated contract market, which I'll explain later, is genuinely novel. Now, by the end of this episode, you'll understand things like what a DCM is, how these rules operate, as well as potential questions and answers being posed and answered by regulators. First, let's remember why insider trading is a bad thing. It's obvious at the start, but really, if we go back to when election betting first peaked in America, it's pretty clear why we need rules from regulators like the CFTC here, and why it's important that these rules are being enforced. For context, in the 1840s, that's when election betting first peaked. It's also when America acquired California and when the gold rush began. So this was a really, really long time ago. And election betting has existed in America at least since the 1790s. So why did it peak in 1840? Well, remember, this was at least 50 years since prediction markets gained wider appeal in early America. And by this time, election betting was widely considered a form of vote buying, because candidates were literally paying people to vote for them. That's obviously not good, and that wouldn't be allowed today, though candidates paying people to vote for them is kind of what happens when people vote for things like universal basic income, right? Okay, sorry. I promise I'll keep politics out of this. Sometimes I can't help myself. Anyways, financial positions in election outcomes distorted voting in several ways. Most importantly, whoever wagered on politicians had a significant financial incentive for that person to win, obviously, which led to some positives like voting, publicly supporting candidates, and negatives because people were willing to tolerate and even encourage election fraud so that their bet would hit. Now, it was around this time that election betting prohibitions began to emerge across several states. Many of these actually prohibited anyone who wagered on an election from voting in that election. Now, think about the implications of that for a second. If you could convince the supporters of your opponent to bet on an election, you could get their vote disqualified. There was one savvy politician who understood that and convinced opposing Democrats in swing states to wager on the election. He disqualified their votes by doing so. You might recognize his name, Abraham Lincoln. Yes, that was in 1864. Now, despite these concerns and prohibitions, prediction markets were extremely popular. Millions of dollars flowed through them, and like the rest of the American financial markets at the time, began to centralize in New York City. How about those Knicks? That Game 4 comeback is definitely the best NBA Finals game I've ever seen. Love it. Anyways, these prediction markets were seeing millions of dollars, yes, millions in the late 19th century flow through them. Unlike today, though, those markets had little regulation or government oversight, but they still worked. People wagered real money on what they expected to be the correct outcome, making prediction markets the most reliable source of forecasting information. So much so that, as I've said before, New York's major newspapers were citing them regularly throughout the 1920s and 30s. Now, today's version of prediction markets are also working much better than any alternative. Here's Chris Giancarlo, an attorney and the former chair of the U.S. Commodities Futures Trading Commission, or the CFTC, which is the primary regulator of certain prediction markets. More on that later. From an interview we recorded in January. Now, I told you I've been working on this episode for a while, and yes, we recorded this in January 2026. Here's Chris Giancarlo to explain prediction markets and the benefits that they offer.
So first of all, I think this activity has great social utility. Think about all the aspects of our lives that are really important that we have very little certainty on. Will an air traffic controller strike go another week or so, in which case I might want to cancel that trip to Chicago rather than get caught in a storm? Will government shutdown take place? And therefore, my cousin who works for the government might not get his paycheck or her paycheck. What about elections that certainly have consequences on industries? If I'm working in the energy industry, the last election may have made a big difference into whether, I could expect a promotion or even to continue in that field. So many things that happen externally to us have great impact on our lives, and yet there's no predictability. There may be polling, there may be media accounts and opinions, but really very little certainty. In fact, the average poll polls maybe 1,200 people. And suddenly now you have this new area of prediction markets where you can draw together tens of thousands, hundreds of thousands, some case millions of people taking an educated view, an incentivized view as to the future. In 2024, more people around the world went to the polls than ever before in recorded history. not just here in the United States, but in France, in Japan, in India, and elsewhere. And in every case, the prediction markets got those results right, providing a great deal of certainty to people whose livelihoods or lives depended on the outcome. And so that type of predictability gives greater certainty to our lives. I think once people get used to these, there's no turning back. And therefore, just like Uber, which when Uber came around, ran into resistance of local taxi and limousine commissions at the city level, at the county level, at the airport level, and had to break through each one of them and not replace taxis because they're still there, but augment them in a way that gives greater certainty. I can fly somewhere and know I'll be able to get an Uber or if I'm out late at night in an uncertain part of town, I call an Uber and get home. I can call an Uber for my daughter and get her home. Uber has been a great social advancement. Uber, Lyft, ride sharing systems. And people have gotten used to it, and it was people's satisfaction with the service that ultimately broke through those local monopolies and those local legal blockages to furthering this innovation. I think you're going to see the same thing here. I think it's going to break through in the same way.
Now, Chris made some great points there. I want to just double click on his last, which is that prediction markets will break through the same way Uber did. That raises an obvious question. What is it that prediction markets need to break through? Well, there's a few things. The first is obviously widespread user adoption. How many times have you used a prediction market? I'm guessing the answer is probably less than you'll use it in 10 years from now. And that has effects on the market themselves, as less overall money means less liquidity, which makes it difficult to keep consistent pricing and makes them more susceptible to manipulation. The second and more important point is the legal question that Sam Enzer of Cahill alluded to earlier. Certain states are using taxpayer dollars to challenge prediction markets and their primary regulator, the Commodities Futures Trading Commission, in courts across the U.S. I spoke to Josh Sterling. He's a former division director at the CFTC and currently a partner at the law firm Milbank, where he and his team act for Kalshi in several lawsuits. He explained that the number of ongoing lawsuits that are solely on the topic of prediction market jurisdiction is probably in the mid to high 20s now.
It's well over a dozen cases. Probably over 2 dozen if you consider there are some states that have sued multiple exchanges. There's some states that have been sued by multiple exchanges. And then you have the CFTC bringing their own suits. So I think it's over 2 dozen suits right now.
We'll talk more about those cases, and you'll hear from Josh much more throughout this episode. But the only way to really understand these lawsuits is to understand how we got here, is to understand the chronological development of the law as well as the prediction market industry. To understand how we got here, we first need to understand why prediction markets mostly disappeared from American life. Now, this could be the time where I have cool transition that takes me back in time, but I'm not doing that. We're substantive here. You're too smart. You're too good looking for me to do that. So in the early 20th century, as I said, the New York Times, New York Sun, and World all provided nearly daily quotes from prediction markets in early October until election day for the elections in 1896, 1900, 1904, 1916, and 1924. What changed, right? Why did prediction markets stop playing a societal role? When did that happen? A great question that really academics have wondered for years and didn't really have a good answer. So again, let's rewind back in time. You see, in New York, which was then the unofficial capital of election betting in the U.S., election wagers had actually been unenforceable in civil courts since an 1814 case, Vesher v. Yates, which held that you couldn't turn to the courts to force someone to pay up if you won. So say I wagered on the Knicks beating the Spurs in 5 games. Had I won and you refused to pay, I wouldn't have had any government-backed remedy. This had a huge impact on the market, obviously. The inevitable result of the government refusing to honor these contracts, and given the enormous demand, meant that any marketplace for election betting would need to take enforcement into their own hands. That institutionalized the markets because bettors couldn't sue to collect. The Wall Street firms that offered these platforms came to basically be escrow services, middlemen who would ensure the parties were paid out appropriately. This resulted in a system in the late 19th and early 20th centuries that grouped together, I'll spare you the nuance here, to be called the New York Curb Exchange. Members of the New York Stock Exchange were eager participants on the Curb Exchange. Now, the roaring 20s bull market that led up to the Great Depression and the post-war financial expansion were a boom for Wall Street, but it also made Wall Street extremely self-conscious about reputational distinctions between investment and speculation. So in 1924, Wall Street wanted to separate what felt like similar activity on stock market and prediction markets. Remember, making a bet on a company's success on a stock market isn't too dissimilar from making a bet on a particular company's outcome on a prediction market, like the number of cars sold by Ford. So in May 1924, a presidential election year, both the New York Stock Exchange and the New York curb market passed formal resolutions barring their members from engaging in election gambling. Now, remember, people couldn't turn to the government to enforce their bet. That made the market dependent on these institutions. Now, with these institutions pushing the activity out, again, to ensure the public wasn't confused about equities markets versus prediction markets, there wasn't really any way to enforce your winnings. With these prediction markets hamstrung on enforceability by both the government and institutions, they pushed further underground to the point where the supply for those markets was so scarce that there was a bit of a void. And voids are usually where criminals thrive, and some criminal enterprises came in to offer prediction markets. But the other void, which really was the demand for accurate forecasting information, was filled by something else. The void, at least for media like newspapers, was filled by a new instrument, new at the time: public polling. Starting in 1916, the Literary Digest ran a national presidential straw poll that became one of the most famous and trusted election forecasting tools in American politics. They would mail out millions of postcards to subscribers who correctly predicted multiple elections, including Franklin D. Roosevelt's first win. By 1932, the Literary Digest was mailing 20 million postcards for these polls, which I believe were the world's largest at the time. But then 1936 happened. It changed the course of history, at least the course of history for what we're talking about today. As mentioned, the Literary Digest had become the de facto poll for Americans. They used their straw polls to forecast the future. The problem was that these polls were essentially a self-selected mass survey, since anyone could mail in the postcards, and this tended to produce a biased sample of people who subscribed to the Literary Digest. And in 1836, they got it wrong, really wrong. That's when a man named George Gallup came in. You might have heard of Gallup polls. Instead of a mass mailer, Gallup used a smaller, more representative scientific sample with statistical adjustment. And prior to the 1936 election, he conducted his poll. The Literary Digest conducted their poll as well. The Literary Digest thought Alfred Landon, based on their poll, was going to win, whereas Gallup predicted, based on his polling, that Franklin D. Roosevelt would win. He also explained why. Well, Roosevelt won by the largest electoral college landslide ever. Suddenly, Gallup polls were hot, and the newspapers turned to them to understand the nation's sentiment and forecast future results. Literary Digest folded just 2 years after this debacle, which brings us back to prediction markets. Gallup's scientific representative sample polling dominated forecasts since 1936. Prediction markets are the first serious challenger to that approach. That's because prediction markets are simply an information aggregate mechanism, one that doesn't rely on representative sampling selected by researchers, but instead on the incentivized beliefs of participants who have something at stake. Here's Koleman Strumpf, again, the professor at Wake Forest, to explain why he began teaching one of the world's first courses on prediction markets back in 2008.
As an economist, like prediction markets always sort of seem like a logical tool for the question of forecasting. Like 30 years ago, when I was kind of starting fresh as a researcher, I would see political polls and they were sometimes good and sometimes bad. And as an economist, I was always like, is there a better way to try to forecast who wins an election than a poll? I mean, polls seem to have a lot of problems, part of which I knew from just self-reflection. If somebody called me up on the phone and said, like, how are you going to vote? I don't know. I'm not going to think very hard about it. And I'm just going to tell them something to get them off the phone. And my concern is, multiply that by everybody else in the poll, and the poll's not going to work so well. Everything in my bones as an economist said, look, how do prediction markets work? You incentivize people to learn about some outcome like an election, and then they go gather up information, and then the market reflects that information. You get a pretty good forecast. And that made sense to me, but I'm like, okay, let's put myself in the feet of somebody in 1904 betting in one of these markets. What information do I use? Well, there are no scientific polls. We don't have radio. We don't have television. We don't have much of like anything in terms of information to collect. Like the only kinds of things that I'd read about is there would be people who would go listen to politicians give speeches and hear how people respond. And that seems pretty coarse to me in terms of information. So I just didn't think these things were going to work very well. Nonetheless, as you point out, these things worked incredibly well. Like they basically are, what an economist would say was well calibrated. When they said a candidate has a 60% chance of winning, if you collect a bunch of those elections, about 60% of the time those candidates win, and 40% of the time they don't win, which is kind of what an efficient market would predict. So they would pretty much tell us, they were pretty accurate in forecasting, and they would do other things like they would, you could see in a market when there's like a landslide. So like in 1920, when you have Harding getting elected president by a landslide, months before the election, the markets pretty much said, look, he's going to win. So like they could figure out who was going to win. You could get a sense of the magnitude of the victory. So they were really quite impressive. And again, it's one of the magics of markets is always we can see that they work, but we don't always know why they work.
So the prediction market story begins again with Kalshi and Polymarket, right? Wrong. The story actually picks back up in the 1980s when 3 economists at the University of Iowa created, quote, an experimental and academic program, unquote, which became the precursor to the modern prediction markets. The idea came to them over a 3-beer lunch at a bar, which is completely irrelevant, but I wanted to include that because I think that's fun. Professor Robert Forsyth and 2 of his University of Iowa colleagues wondered how economics might do a better job than traditional polls. Gallup's polled method had been working, but these Iowa researchers were curious as to whether the seemingly lost art of prediction markets could again predict election outcomes better than the public opinion polls that Gallup popularized. Remember, these market-based polls, these market-based forecasts were the norm. Gallup polls were sort of the outlier throughout history. And these Iowa professors were right. They created a political stock market, operated it across 9 elections from 1988 to 1991, and beat public opinion polls every single time. As Andreas Park, a professor at the University of Toronto, has pointed out, in 1988, the Iowa electronic market, which is what the researchers named their platform, forecast the results of the presidential election far better than major polls. It estimated that Republican George H.W. Bush was likely to win 53.2% of the popular vote. He emerged with 53.4%. In the following decades, the Iowa electronic markets outperformed polls 74% of the time. But of course they did, right? I mean, someone betting on an outcome is much more incentivized to be correct than someone filling out a survey. Like if you ask me who's going to win the 2026 Super Bowl, I'd tell you it's my Bengals. I'm a Bengals fan. We've got the 3rd easiest schedule, a better defense, and a healthy Joe Burrow. But if you ask me to bet on who I thought would win in 2026, there's no chance I'm betting on the Bengals. I'd probably pick the Rams, especially after that Myles Garrett trade. Anyways, that's all to say that these Iowa professors brought back prediction markets. By 1992, they wanted to expand participation for the upcoming U.S. presidential election beyond state borders, but they wondered about the legality of it. So they turned to what they believed was the relevant regulatory body for these markets, the Commodity Future Trading Commission, or the CFTC, to ask for permission. Now, if you're this deep in the podcast, there's a good chance you're familiar with the CFTC. If not, they regulate financial instruments around commodities in America, starting with things like wheat and oil. Their jurisdiction has expanded to include purely financial instruments, things like interest rates and foreign exchange, as well as swaps. Swaps are the key term we're going to unpack here, and don't worry, I'm going to explain exactly what they are. First, why did these researchers turn to the CFTC for permission? Well, they thought that their product, which was a real money bet on election outcomes, might have been governed by the Commodity Exchange Act, which is the law that the CFTC is tasked with enforcing. Now, if the Iowa electronics market was governed by the CEA, the Commodity Exchange Act, then they would need a license to offer this market. With this license is called a designated contract market, or DCM. So these researchers thought they needed to have a DCM, otherwise they might be committing a federal crime. Now, there are 3 main reasons why they thought that. First is, and most importantly, is what's considered a commodity under U.S. law. As I mentioned, the relevant law here is the Commodity Exchange Act, which regulates the trading of financial instruments relating to commodities in the US. Specifically, Section 1A9 of the Act defines a commodity as a broad list of tangible goods like wheat, corn, wool, as well as all services, rights, and interests in which contracts for future delivery are presently or in the future dealt with. Before I get more detail here, what is a futures contract? It sounds more complicated than it is. A simple way to understand it is to invert the words futures contract. It's a contract for the future delivery of an asset. You're buying something now that can be redeemed for something in the future. If you want a super detailed explainer on futures, episode 202 of Law of Code covers that in great detail when looking at perpetual futures. That episode's at over 140,000 impressions and the feedback has been great, so really recommend you check that out. Basically, all you need to know is that the definition of a commodity under the CA has expanded over time. And these researchers believe that their prediction market was captured here. And that's why they went to the CFTC, the regulator here, to ask for permission to operate the Iowa electronics market. This research-focused nonprofit project that had correctly been predicting election results was granted permission from the CFTC to operate without the costly structure of a licensed designated contract market, or DCM. The CFTC gave a few reasons for that. They cited the small number of users, the research aspect, and the fact that the highest maximum investment anyone could make was $500 for reasons for allowing the IEM, the Iowa electronics market, to receive a no-action letter from the CFTC. A no-action letter is basically just written assurance from the regulator's staff that they will not recommend enforcement so long as the particular activity is conducted in the way it's been explained. And this was way back in 1992. With the then director of the CFTC's Division of Trading and Markets sending a no-action letter to one of the Iowa professors. And in that 3-page letter, the director wrote that the interest at issue was, quote, more closely resembling a futures contract than a stock, unquote, which is why these markets were within the CFTC's jurisdiction. And that jurisdiction, as we'll see throughout this podcast, is being challenged by states, by gambling businesses, and by tribes across the U.S. today. Now, I only mention this Iowa electronic markets, IEM for short, because it's kind of the foundation for everything that came next. Before we get to today's situation, here's a quick timeline after the IEM no action letter, because they weren't the only group interested in prediction markets. So in 1988, this is when IEM pioneered the binary contract structure, which is basically you make your bet, you get $1 if the event occurs, and you get nothing if it doesn't occur. In 1992 was when the CFTC granted IEM the no-action relief. 4 years later, the Hollywood Stock Exchange launched in California, which was a play money market on movie box office performance and Oscar outcomes. Then in 1999, InTrade was founded by American floor traders, with Trade Sports created as a separate sports-focused sister company. Trade Sports was one of the first examples of prediction markets that were actually for profit, I believe. They gained international attention in 2003 for correctly predicting the capture of Saddam Hussein. From 2004 to 2008, InTrade became the dominant offshore venue that correctly predicted multiple presidential outcomes, the papal election, and most major political events of the period. We also saw many internal prediction markets emerge at companies like HP, Google, and Microsoft that were used as forecasting products. But the big change came in 2010. When new regulation was enacted after the financial crisis. This is the most important point for all that litigation that Josh Sterling of Milbank and I discussed earlier. You see, following the financial crisis, the government response was to pass laws that regulated event contingent derivatives that were previously largely unregulated and played a major role in the financial crisis. Now, if you've ever seen the movie The Big Short, if you haven't, really recommend, one of the best movies ever. If you haven't seen it, in that movie, they talk about credit default swaps. These were the instruments most at blame for causing the financial crisis. Now, credit default swaps are an example of an event contingent derivative, something that if this happens, then you get a binary outcome. Much like prediction markets are event contingent derivatives. So Congress regulated these instruments through the Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010. This act, Dodd-Frank for short, added the definition of swap to the Commodity Exchange Act with a new paragraph, number 47, containing the swap definition. You see, before Dodd-Frank, swap, which is what prediction market seems to fit in, was not a defined term in the Commodity Exchange Act. Now, why does the definition of swap matter so much for prediction markets? You're getting a lot at once, but I appreciate you drinking from the fire hose with me here, because the importance is pretty obvious once you hear the definition. You see, there are 6 major prongs that define a swap, but the one that is most relevant to prediction market is this. A swap includes any agreement, contract, or transaction where payment is, quote, dependent on the occurrence, non-occurrence, or the extent of the occurrence of an event or contingency associated with a potential financial, economic, or commercial consequence. So this is basically saying, and this is the definition of swap in the CA, that anything dependent on the occurrence of an event with potential economic or commercial consequence is captured. And if you think about how prediction markets work, you're betting on a particular outcome happening. That's captured by the CA. And there's more language that sort of is at the core of the lawsuits that are happening today. Now, speaking about the importance or sort of the core of litigation is a related point. And part of it goes to the legislative history here, because people argue that this swap definition was passed after the financial crisis. It wasn't intended to capture sports betting, because sports betting are such a huge part of what prediction markets like Kalshi and Polymarket and Crypto.com's OG markets offer. Now, let's go back to the congressional record to actually see what happened here, what the truth is. Now, the author of the event contract / swap provision, Senator Blanche Lincoln, a Democrat from Arkansas, was questioned about this exact term. Now, here's the question posed to Senator Lincoln, who was then the chairwoman of the Agriculture, Nutrition, and Forestry Committee on the topic of event contract. And this is a question from Senator Feinstein. Quote, I'm glad the senator is restoring this authority to the CFTC. I hope it was the senator's intent as the author of this provision to define, quote, public interest, unquote, broadly, so that the CFTC may consider the extent to which a proposed derivative contract would be used predominantly by speculators or participants not having a commercial or hedging interest. Will the CFTC have the power to determine that a contract is a gaming contract if the predominant use of the contract is speculative as opposed to a hedging or economic use? Now, before I talk about Senator Lincoln's answer, I just want to explain a bit about what I talked about there, because what Senator Feinstein's basically referring to is the public interest part of the act, the Commodity Exchange Act, that had been implemented with this event contract provision, which basically says that CFTC may prohibit any contracts that they deem to be contrary to the public interest. And what Senator Feinstein wants to confirm here is that, hey, the CFTC is going to have this power, right? Here's Senator Lincoln's response. This is directly from the congressional record. Quote, that is our intent. The commission needs the power to and should prevent derivative contracts that are contrary to the public interest because they exist predominantly to enable gambling through supposed, quote, event contracts, unquote. It would be quite easy to construct, quote, an event contract, unquote, around sporting events such as the Super Bowl, the Kentucky Derby, and Masters golf tournament. These type of contracts would not serve any real commercial purpose. Rather, they would be used solely for gambling. Now, that quote has been cited often by the critics of prediction markets, but I think it's important to note that this is the senator saying what she thinks should be within public interest, what she thinks should serve a commercial purpose. Markets can respond very differently to that. That quote is often cited by Daniel Wallach. He's an attorney. He's a professor who has his own firm. He's a sports gambling and betting expert. It's often used by others who use it to push back against event contracts as including sporting events as swaps. Here's Daniel.
Senator Lincoln used the example of Masters, the Super Bowl, and the Kentucky Derby as being the type of gaming that shouldn't be available on the derivatives market. The CFTC interpreted the word gaming somewhat consistent with Senator Lincoln's approach. When it enacted Rule 40.11A1 in 2011, it was a unanimous adoption of the rule, and the adopting release, which is 23 pages long, makes specific reference to the legislative history which refers to sporting events.
Now, we'll dive into that Rule 4011 in detail. However, it's important to note that Senator Lincoln did say the commission has the power to, and I love the movie Dune and the books as well. One of the key ideas in Dune is that the person who has the power to destroy the spice controls the spice. And here, it's very clear from both the record as well as the way the rule is written that the CFTC is meant to have control or jurisdiction here, as it has the ability to prohibit these sports event contracts if they are against the public interest. Now, remember, at the time when these rules were drafted, the public interest was that no sports gambling happened. But the public interest has since changed, where we have a proliferation of sports betting. So suddenly the public interest doesn't really group sports betting in the same way it groups assassination and terrorism, other terms that previously gaming had been associated with, which we'll get to in a second. Now, we also heard from Senator Lincoln, the one who had previously explained the intent behind this provision on this exact topic. Here's Josh Sterling, formerly of the CFTC and now a partner at the law firm Milbank, who represents Kalshi in multiple matters, to explain what we've heard from Senator Lincoln since in further detail.
So Senator Feinstein and Senator Lincoln had this colloquy, which was inserted into the congressional record, making this point that in their view, having certain contracts and certain events like the Derby and the Masters and the Super Bowl on exchange is, maybe not the best thing. And I'm not quoting it as either stronger or weaker than that, doesn't matter. So 2 senators said that. Then the whole Senate passed a bill and the president signed it. And then what did that bill basically say? Well, the solution to that was to give the CFTC jurisdiction over those products and then give them the ability to make a determination that those contracts were against the public interest and shouldn't be listed. So they said that. And then the Congress said, okay, well, let's let the CFTC handle it, not the states. So it doesn't get to the states, even if you look at what those senators said. And look, Senator Lincoln, with a couple other senators, including Senator Chambliss, wrote an amicus brief in our case in the Third Circuit against New Jersey. And they basically said, Kalshi's right. What we meant to do in Congress was to cover a lot of instruments in Dodd-Frank and make sure that there was uniform federal regulation. So if we're going to listen to what a senator said, I guess, or 2 of them, we could listen to those that signed this amicus, including the one who made the statement in 2010 to tell you what she meant. But again, I don't have to worry about that because the statute's very clear on its face.
Again, I think it's important to remember that the statute, literally the words in the law, says that a swap includes any agreement, contract, or transaction where payment is dependent on the occurrence, non-occurrence, or the extent of the occurrence of an event or a contingency associated with potential financial, economic, or commercial consequence. So anything associated with an event where payment is dependent on the occurrence or non-occurrence of that event that has economic or commercial consequence. Here's Thania Charmani. She's a litigation partner at Winston Taylor, who also addresses the statement by Senator Lincoln, which again, Senator Lincoln later wrote an amicus brief explaining. Here's Thania.
I think most of the discussion focuses on a statement by Senator Lincoln, I believe, when the CA in 2010 was adding Section 5, referring to the possibility that these contracts will no longer include gaming. But that's not what the CA said. It might have been how the senator wishes the CFTC acted, but that doesn't take it away from the CFTC. So I do think that we need to keep in mind that when you put that on a DCM, it's under the CFTC's exclusive jurisdiction, and you just cannot get around this language in the Act.
A quick side note before we continue. Like me, you're probably thinking, okay, event contracts are within the CFTC's jurisdiction, but what about multiple event contracts? Event contracts that are combined to form parlays. Surely those aren't swaps. And that's sort of what I was thinking too. But if you read the definition of swap, it also includes, quote, any combination or permutation of or option on any agreement, contract, or transaction described in any of the prior clauses, which to me suggests that parlays that are made up of event contracts that are traded on DCMs, swaps, are within the definition of swap. And I asked Josh Sterling, a partner at Milbank and former CFTC division director, about that.
Yeah, so I think the fundamental premise is a swap plus a swap is a swap. And so if you had two swaps together that were event contracts, they would be swaps. They would be treated like that all the way. The whole point of that is to sort of say, well, you can't just try to avoid or skirt around regulation by putting two things together and calling it something else. So it was really the substance of it. I think, objections to parlays I have heard are that, what's the hedging purpose of a parlay or a combination contract? Well, there's no requirement to have a hedging purpose for any contract you enter into. There's no motivation test when you go to trade. And so is it capable of providing a hedge? Maybe, but it's also an information discovery tool. And I think that the proposal that came out today by the CFTC, all 267 pages of it, sort of make the point emphatically that the statute does not require every contract to provide a hedging purpose, and that it can serve economic interests, the trading of it, that go beyond the interests of the two people trading the thing. That's a long way of saying, if you have a regulated market and it has an instrument and you want to trade it, you can, and then that will generate information that is useful to you and useful to other people observing the market who also happen to have an interest in the underlying commodities, the events.
So we will talk at length about the CFTC proposal that was live in early June and hear directly from a member of the CFTC about it in a few minutes. But first, I want to do a quick recap of where we are now, because it's probably a good time to remind you that I'm not an investor, nor am I sponsored by any prediction markets. I don't have any financial stake in this. I just want to educate people on what the law is so we can make better rules and live in a better world. So quick recap. We've got a definition of swap that includes any agreement, sort of contract or event that is dependent on the occurrence or non-occurrence of an event that has some sort of financial or commercial consequences. Basically, an event contract, a prediction contract, falls within the definition of a swap because of how it operates. That's partly, but not exactly, what's being challenged in most of the ongoing legal cases. We mentioned the testimony from Senator Lincoln as well, which is part of that challenge, but there's more. You see, Section 2A1A of the Commodity Exchange Act, which governs swaps like event contracts, grants the CFTC exclusive jurisdictions over swaps that are traded on designated contract markets, which again are these exchanges that are licensed by the CFTC. So think of these as like the legal vehicles to offer swaps. And it's so important because we're not capturing everything here. We're only capturing the prediction markets where swaps are offered on licensed DCMs. Once you've established that an event contract is a swap and traded on a DCM, the CFTC's exclusive jurisdiction follows automatically. Therefore, if a prediction market is a swap and traded on a DCM, unless you've got some form of relief from the CFTC, as we saw from the Iowa electronic markets, there are certain rules, CFTC rules, that apply to DCMs that must be followed. Some of these rules are at the heart of ongoing litigation. We've already covered one, which is the insider trading question, but it's not the most important, at least not when it comes to the majority of these lawsuits. The most important of these rules goes back to Dodd-Frank. Remember that act that was passed in the aftermath of the financial crisis. One of the Dodd-Frank amendments to the Commodity Exchange Act provides the CFTC with authority to prohibit trading in certain types of event contracts under what is now known as the special rule contained in Section 5C, a bit of a mouthful, of the Commodity Exchange Act. We're going to just call it the special rule. And this is what drives much of the current litigation. It's been referred to by many people throughout this episode. It was what Senator Lincoln in her congressional sort of testimony was talking about. What does the special rule do? The special rule authorizes the CFTC to deem event contracts contrary to the public interest if they involve any of the 5 enumerated categories: gaming, terrorism, assassination, war, or activity that is lawful under federal or state law, or any other category the agency designates by formal rulemaking. Now, there is little debate over terrorism, assassination, war, or contracts that involve unlawful activity. Gaming is obviously the big question, as is the word involve, because the majority of volume on licensed marketplaces like Kalshi is in sports. Now, some argue that any interpretation of this special rule that permits the CFTC to regulate sport event contracts is actually allowing the CFTC to regulate gaming or the gambling industry as a whole. Here's Thania Charmani, again, a partner at Winston Taylor, to explain why that's not exactly true.
I think it's slightly misrepresenting the text of the CEA and the argument that the exchanges are making before the courts to say that they're taking the position that Congress intended for the CFTC to regulate gaming. This is not what they're saying. What they're saying is that the CEA granted the CFTC exclusive jurisdiction to regulate transactions on designated contract markets, whether or not the underlying contract involves gaming. So it's not that suddenly the CFTC wants to infringe on the state's rights to regulate gaming, is that the CEA clearly and unequivocally said that the CFTC will regulate these transactions traded on DCMs, will regulate swaps, will regulate these events contracts. And by the way, in 2010, it added this provision, Section 5, under the Dodd-Frank Act, saying if the Commission believes that these contracts violate public policy, including 5 enumerated categories, naming gaming, the Commission may determine that they shouldn't be listed. That should be the end of the discussion. That's the truth. These cases have one question presented before the courts. Is it the CFTC's job to regulate these contracts on DCMs, even if they involve gaming, or not? And the CEA said, yes, the federal government has exclusive jurisdiction, and yes, the CFTC will control over all of these contracts, even if they include gaming. There is really no good argument based on the text or the history of this legislation that Congress intended for gaming event contracts to be regulated by the states.
The special rule, as I said, is what Senator Lincoln was talking about when she said, quote, the commission needs the power to and should prevent derivative contracts that are contrary to the public interest, unquote. In a separate question following the sports-related question, Senator Lincoln is asked by Senator Feinstein whether she agrees that this provision will also empower the commission to prevent trading in contracts that may serve a limited commercial function, but threaten the public good by allowing someone to profit from events that threaten national security. Here's what Senator Lincoln said, quote, I do. National security threats such as terrorist attack, war, or hijacking pose a real commercial risk to many businesses in America, but a futures contract that allowed people to hedge that risk would also involve betting on the likelihood of events that threaten national security. That would be contrary to the public interest, unquote. So the CFTC was granted the ability to, not forced to, remember, because the statute says the CFTC may prohibit. The CFTC is allowed to determine whether or not those type of contracts were against the public interest. And those were gaming, terrorism, assassination, war, or unlawful activity under federal or state law. So what did the CFTC do? As Daniel Wallach explained earlier, the CFTC enacted Rule 40.11 in the summer of 2011. Rule 40.11 is the CFTC's implementing regulation for the special rule. So basically, the rules in the statute, that's the 5C, C5C, but then they had to write rules that sort of followed that. And this rule prohibits any CFTC-regulated exchange from listing event contracts that involve, relate to, or reference the categories Congress enumerated in the statute, including gaming. The rule expands the trigger from involve to involves, relates to, or references. Now, that broadens the scope beyond just what directly involves the prohibited category and might have been an extension of the law without congressional approval. But this rule, as it currently stands, is being cited by entities like states, like gambling companies, like tribes, to prohibit or ban prediction markets. They're saying, hey, CFTC, you've put out this rule that says they can't reference in any way these types of gaming contracts. You shouldn't be allowed to do that. But it's important to note that this is a rule that interprets the statutes, and rules can be changed by the agencies that wrote them so long as the rule change follows the law. And that seems to be what's happening today. In June of 2026, the CFTC published a notice of proposed rulemaking that would modernize the special rule, that Rule 40.11. Before we hear directly from a member of the CFTC on the purpose behind that, here's Stefan Schropp. He's a senior regulatory counsel for the VC firm Paradigm, which has invested in Kalshi, to explain what CFTC Chairman Michael Selig has done to get us here. Stefan, like the rest of us and like the rest of the guests in this podcast, is only expressing his own opinion and not that of his firm.
So just as a quick background, Chairman Selig came in at the beginning of the year and in February put out an advance notice of proposed rulemaking that spanned 300 plus questions over 300 plus pages, basically touching all aspects of prediction markets. And what this NPRM is one outgrowth of that. And we heard Chairman Selig go on TV earlier this week and, kind of preface that this was going to be a narrow rule, that it was going to be a first step, but it wasn't designed to be comprehensive. And it wasn't. It didn't address everything that was in the ANPRM. So what I think the combination of those two things signals, first, Chairman Selig and the CFTC are taking a systemic approach. They're looking at all aspects of prediction markets. And then secondly, this is a first step. He's taking a kind of sequential approach, and he's starting, and I think the big takeaway from this NPRM is he's starting kind of at first principles with the question of what can be listed on a DCM, right? And that, I think if you were going to answer the various questions that need to be answered, you start with what can you list? And so that's how I think about this NPRM. Is I think it is a first step. I think it is a thoughtful, and for a first step, it stretches to 260 plus pages. So it is comprehensive of what it seeks to address. But I think it signals that the CFTC is prepared to engage in a lengthy and holistic review of prediction markets.
So why did the CFTC produce this now? Here's Michael Passalacqua. He leads the Innovation Task Force at the CFTC and is senior advisor to Chairman Selig about the purpose behind publishing the 260 plus page proposal, as well as what he expects to happen next.
Thank you, Jacob. Thrilled to be here. Michael Passalacqua, Senior Advisor to Chairman Selig at the CFTC. I also lead the agency's Innovation Task Force. And I just want to say before I begin, I must note that the views I express and share today are only my own views and do not necessarily reflect those of the chairman or of the commission. I just need to make a standard disclaimer that, certainly can't prejudge any of the issues within the rulemaking subject to the comment period right now. So I'll just speak more at a high level. But really what the proposal does is, one on June 10th that you mentioned, is try to modernize Rule 4.11, which is known as the special rule, that authorizes the commission to determine whether an event contract involving certain enumerated activities, such as those involving terrorism, assassination, war, gaming, is then contrary to the public interest. And so I would say the core problem that the NPRM seeks to address is ambiguity, right? The proposal seeks to deliver regulatory clarity by setting out clear criteria for determining when an event contract, say, involves an enumerated activity, what the enumerated activities are, and the parameters for the CFTC's public policy review, including certain factors that may be considered. And I would say, it also proposed amendments identifying categories of gaming-related contracts that pose heightened public policy risks. And so ultimately, the goal with this proposed rule is to ensure that these markets benefit from a framework that encourages responsible innovation while upholding market integrity.
Now, before we get into what Michael and Chairman Selig and the team at the CFTC have put forward to modernize the special rule, it's important to note that this rule is being relied on by the states in litigation against prediction markets. So let's dig into that litigation now. Importantly, there's obviously a lot at stake for the states because they generate significant tax revenue from gambling. The American Gaming Association estimates that legal sports betting alone generated over $2 billion in state and local tax revenue in 2024. New Jersey collected over $115 million in sports betting taxes alone, and that's money that's used to fund public works across the state. There's also tribes, which in many states have the sole exclusive right to operate certain forms of gaming or gambling within the state in exchange for substantial revenue sharing payments. And these groups have all tried to prohibit prediction markets from existing in their particular jurisdictions. It started with cease and desist letters where state gaming regulators sent written orders to prediction market companies telling them to stop offering specified products to residents in that state, typically the sport event contracts. At least 14 states have sent letters of these types to prediction markets. Then, if those don't work, they go to civil enforcement actions. So several states have moved to file civil claims, either through gaming commissions or state attorney generals, they file in state courts alleging unlicensed gaming, seeking injunctions which would stop the activity, as well as civil penalties. Now, the third sort of step, and one we've only seen in Arizona, I believe now, is criminal prosecution. This is where county prosecutors move towards criminal charges against Kalshi for unlicensed gambling operations. We've also seen several states introduce bills that would either explicitly ban prediction market activity on sports outcomes or impose tax regimes that are designated to make products commercially non-viable. Now, these groups have to argue something, right? They can't just say, well, we don't like prediction markets. They shouldn't exist. They argue a few things, many of which are clear in Kentucky's lawsuit against Kalshi and Polymarket for, quote, doing business in Kentucky without a gaming license or following state regulations, unquote. I asked Josh Sterling, a partner at Milbank, one of the firms defending Kalshi across many lawsuits, to summarize the core questions of these lawsuits.
I think there's two. One is really the foundational question is, does the Commodity Exchange Act give exclusive jurisdiction over DCMs to the CFTC?
Interesting. Okay.
And is that preemption? I think the answer to that's pretty readily yes. So then the question becomes, okay, the CFTC has exclusive jurisdiction over trading of swaps, including swaps on a DCM. Second question is the one you hit on. Are these contracts swaps? And, I think the answer to both questions is yes. I think exclusive jurisdiction means no one else has jurisdiction. There's no magic words you have to use to say preemption. And it's very clear. So there's no presumption against preemption, which is an argument we've seen that exists where law is murky and doesn't say things like exclusive jurisdiction. Are these swaps? Well, sure. It's right in there. And the definition is also exceedingly broad and overlapping. It was meant to be quite broad. And, event contracts are referred to as swaps later in the statute, literally. And also the definition includes instruments that now or in the future come to be known to the trade as swaps. So it's supposed to continue to grow. So it was written broadly and meant to get broader still. And I think we're comfortable within it. So yes, I think these are swaps. And yes, I think they trade on a TCM. I think it is just that simple. People who don't think it's that simple will roll out the Congress does not hide elephants in mouse holes, where you sort of look at it from the wrong end of the telescope or whatever. And you say, well, it can't just be that you could trade these contracts on DCM. That just can't be right. So let me find a reason why it's not right. I'm going to apply interpretive canons. I'm going to apply doctrines. I'm going to do everything I can to get around the words of the statute. Okay. We'll see where we wind up. I personally like arguing off the words in the statute.
Reminder, the statute specifies that any agreement, contract, or transaction where payment is contingent on the occurrence of a certain event is going to be covered by the definition of a swap. Now, as for the specifics in the lawsuit, let's use Kentucky as an example. Kentucky recently legalized sports betting and saw their revenue from it jump to $917 million in the second quarter of 2025. I don't know if that's accurate. That seems like really high, but that's what I saw reported online. So obviously, if you're a state, even if the numbers are in that ballpark, you don't want to lose that. In the lawsuit, Kentucky's Attorney General Russell Koleman cites the Interstate Horse Racing Act, which says that, quote, the states should have primary responsibility for determining what forms of gambling may legally take place within their borders. They cite the duck test, writing that, quote, this is sports wagering. If it looks like a duck and quacks like a duck, it's probably sports wagering, unquote. Now, the problem I have with the duck test is when you apply it to anything that's sort of a bet on the future, whether that's in an equities market, prediction market, commodities market, it quickly conflates the two because kind of everything's a prediction to the future. I think it's a very lazy take, frankly, and it's one I asked Paul Grewal. He's a former U.S. District Court magistrate judge and Coinbase's chief legal officer about. Here's Paul.
It's a take which presents exceptions that swallow the rule. If the fact of the matter is that anytime anyone is engaging in a financial transaction to address the uncertainty of the future, if that makes the transaction itself gambling, subject to state regulation, well, then as you point out, there are a whole host of other financial transactions which get swept in as well. And we know that's not the case as the law is written. And yet, I haven't yet heard really any real serious effort to draw a distinction that would allow us to address the former without sweeping in the latter.
Thanks, Paul. What is noticeable in Kentucky's complaint against Kalshi is that they don't mention once that Kalshi is regulated by the CFTC and licensed as a designated contract market. In fact, the term designated contract market isn't mentioned anywhere in the complaint, nor is it mentioned in Kentucky's complaint against Polymarket. Now, in the Kentucky lawsuit and in most others, states are arguing that the wager on the outcome of a sporting event is not a swap, nor is a parlay a swap. My problem with these complaints, though, at least this one from Kentucky, is that it makes that statement, but it doesn't really explain why. And as you've heard in this episode, the black letter law on a swap seems pretty clear that event-based contracts that are traded on DCMs should be swaps. However, the state of Kentucky does make a very convincing argument as to why prediction market offerings meet the definition of a wager under Kentucky law. Because their users risk a sum of money, the price of the contract, on a sporting event for which the outcome is uncertain. That leads to an obvious question where you have two conflicting laws. You have the swap definition, you have the wager definition, you have state law, and you have federal law. And that goes to the legal principle of preemption, which determines what happens when federal and state law conflict. The shorthand, federal law wins. Under the supremacy clause of the U.S. Constitution, when Congress has spoken to a subject within its authority, state laws that conflict with federal laws are displaced, meaning the federal law will govern. And since we already have a federal rule for event contracts that are traded on DCMs, you can't also have a state rule, right? I asked that to Thania Charmani. She's a litigation partner at Winston Taylor. I asked her what would happen if the states won on this claim.
Just creates a vacuum of regulation. It makes it impossible for the exchanges to comply with such a regime where you have the federal regulations and you have state regulations. That also goes into the argument of preemption and whether that's another very valid point of why you cannot have the two regulating at the same time. That goes to implied preemption when an entity or an individual cannot comply with both state and federal law at the same time, then the law says it must be that federal law prevails when it regulates a field like this one. Practically, it just wouldn't work. Like it wouldn't work for Kalshi or Polymarket to have to comply with 50 different state laws on this.
Yeah, no,
and
it
it
won't.
completely ignores why the CA was put in place and how we want to protect these markets and the entire history of the legislative act.
So even if Kentucky is right that prediction market activity fits this definition of wager under Kentucky law, the federal preemption question is still in front of it. And this goes back to the foundation of America, really, which is the Constitution, which says that federal law is the supreme law of the land. State laws and state court rulings that conflict with federal law are displaced. Now, there are 4 preemption doctrines that courts use to work out when that displacement occurs, with, I think, the conflict or obstacle preemption doctrines most applicable here. We don't need to get into detail. Those only just want you to know that those exist. Now, states argue that federal preemption would undo legitimate state interest, including state tax revenue, tribal gaming compacts, responsible gaming programs, and the entire state-by-state framework that the states have spent years building since 2018. And I'm going to get into a bit about the differences between sports books as well as prediction markets, because I don't think that's necessarily true. Back to the case against prediction markets. Kentucky also alleges that prediction markets are advertising to Kentucky residents in a misleading way. For example, when Kalshi opened its platform in sports wagering in January of 2025, their announcement read, quote, "Game on, Kalshi brings 100% legal sports trading to all 50 states," unquote. Now, I mean, if it's offered through a DCM and it's sports trading, isn't that illegal? Kentucky has rules for advertising wagers, which is what they believe this activity is offside of and fits in. Now, I spoke to Matt Kalish. He's a co-founder and longtime president of DraftKings, a sports betting platform, about the advertising that certain prediction markets do. He didn't mention the legality bit. He's not a lawyer, but he did cite how prediction market platforms tend to advertise their markets as being peer-to-peer, whereas you're often usually opposite a liquidity provider. And I think it's important to share these arguments as well, too. Here's Matt.
Just pushing this narrative like this is a nice sandbox to play in as a recreational bettor. And they're not being transparent about how it really works. And that is tricking hundreds of thousands of people into downloading the app, depositing money. Even some things that are, I would say, on the most extreme side that are going to be very problematic. You know, representing that normal people have an advantage over Wall Street.
He added that it's clear that Wall Street maintains the advantage in a similar way with how they do with Robinhood, where Robinhood orders flow through firms that pay to access the information and act on it, beating retail to the punch. Obviously, because the liquidity being provided and the fact that those liquidity providers need some form of return on their money they provide. Here's Matt again.
The biggest thing is retail doesn't typically post liquidity, right? Retail typically takes.
Yeah.
So it's, you go on the site, you see odds, you click on it and you buy it. But what you're buying is all of this liquidity, basically, that's on the order book from the market maker, right? In the sports book, it's the same thing. You're betting against the house. Who pays for everybody's fees and everybody's profits? It's only the app users, right? That's the business of Wall Street. No different than Robinhood sending deal flow, order flow over to whatever banks that they have relationships with.
But questions over liquidity aren't why prediction markets are being sued by Kentucky, nor is it even included in Kentucky's complaint. The fourth point that a lot of states are arguing is that the special rule, so Rule 40.11, remember, which gives the CFTC the ability to prohibit, if it chooses to, certain gaming contracts, shows that Congress understood that gaming was distinct from financial derivatives. The states are arguing that the CFTC interpreted its own statute correctly when issuing the special rule and banning or sort of prohibiting event contracts that involve sports and gaming, and that the agency's current attempts are a departure from the regulation that it's had on its books for years. The final point is that exclusive in the provision to regulate swaps means exclusive against other federal agencies. So this is what states are arguing, that just because the CFTC has a rule that conflicts with states' rules, the actual preemption, the exclusivity of that is only with respect to other federal regulators, not the states. They argue that Congress did not intend to displace state law in areas that states have traditionally regulated, and that gambling is one of the most traditional state regulatory areas. And for regulation to displace it, it should be unambiguous. But I think it's important to remember that, I think we've already mentioned this episode, they're not regulating gambling, right? The gambling is separate. They're regulating prediction markets, these event contracts that are traded on licensed DCMs. So to summarize, it's basically comes down to how you determine this. One side is reading the statute and saying that it's clear and obvious that event contracts fall within the remit of the CFTC when listed on a DCM. The other side is saying, hey, well, if you do all this, you're sort of sweeping in gambling too. That's a simplified way of saying it. But this matters a lot to the CFTC, because if they lose jurisdiction over event contracts that are traded on designated contract markets, well, that can stretch well beyond just sports and could really mark the end, or at least a significant hampering of the federal framework for swaps. So the CFTC countersued Kentucky like they have in many other states, after Kentucky, having failed to stop prediction markets through other means, imposed a prohibitive tax intended to achieve the same goal. This is an update that was explained well in the Cahill Next crypto and AI alerts that Sam Enzer, Lewis Cohen, and the team there shared this morning on June 29th. From that, quote, the CFTC argued that Kentucky's attempts to shut down federally regulated designated contract markets intrude on the exclusive federal scheme that Congress designed to oversee national swap markets. And they criticized the state law taxing prediction market transaction fees at 14.25% as making it impossible for prediction markets to operate in Kentucky, unquote. So just to step back for a second, these taxes are something that states are doing. If they're not winning the lawsuits, if they're worried that they're going to lose in court, they're issuing these prohibitive taxes. And here's Stefan Schropp. He's the senior regulatory counsel at Paradigm, to explain what these states are doing to stop prediction markets.
We have heard state legislators repeatedly say, well, if we can't regulate them out of existence, we'll tax them out of existence, right? And I do think that if the states end up ultimately losing these cases that are currently going on, a taxation regime designed to drive prediction markets out would also not pass muster, largely for the same reasons. If you can't regulate something out of existence, you're going to run into similar preemption and supremacy clause problems if you try to tax them out of existence.
So the CFTC and prediction markets and related businesses are arguing that these prediction markets, these event contracts, are swaps under the Commodity Exchange Act. And as we've said here, if they're traded on a designated contract market, they're under the exclusive jurisdiction of the CFTC. Therefore, state law is preempted to the extent that it conflicts with that exclusive jurisdiction. So every chain in this link is necessary. What should matter isn't the duck test. What should matter in these lawsuits is how these products work, because sports books and what states currently regulate under gambling laws and prediction markets, which the CFTC regulates under Commodity Exchange Act, work very differently on the back end. And the back end is what separates, for example, how perpetual futures operate from actual stock markets, even though they might be trading the same or similar assets. How things work on the back end determines how they should be regulated. And I think this is maybe the most important part of the episode, because I want to explain to you how prediction markets work, because people fear what they don't understand. And people fear prediction markets largely because they don't understand what they are or how they work. Here's Paul Grewal, Chief Legal Officer of Coinbase, as well as a former U.S. magistrate judge, to explain where the fear comes from, remembering that this is just the latest iteration of a centuries-old practice of prediction markets existing.
They're nothing new in large part. Now, their operation and their distribution is something quite new, but people have been making predictions and engaging in making event contracts for many, many, many years. And in some cases, you point out centuries, if not millennia. What I think is at the root of the anxiety or hostility to prediction markets, Jacob, is a sense that everything has become a game. I think there is a fear culturally, at least here in the US, perhaps in Canada, and maybe this is global, that we have turned our economy in large part into games which bear little or no resemblance to work in the form that we knew not so long ago. And so, again, I think much of that is irrational, given the history that you rightly bring up, and given the, I think, critical utility that comes from and is provided by prediction markets in so many cases. But all that said, we have to meet people where they are. And if they can't distinguish between event contracts listed on CFTC registered exchanges on the one hand and casinos or sports books on the other, then we need to explain that to them. And we need to not only explain what those differences are, but make the case for why those differences matter. And that's I think, where this level of conversation publicly goes next.
Now, talk about setting me up. Thank you, Paul. Let's talk about how prediction markets actually work. The easiest way to understand any sort of terminology in law is usually to invert it. These are just markets for predictions, a place where people meet to trade contracts that pay out based on whether or not a specific event happens. When you visit a prediction market like Kalshi, you'll find each contract structured as a yes or no transaction, like, will the Wildcats beat the Cardinals tonight? Say it's a basketball game. Each contract resolves to $1. So if the Wildcats win, anyone who owns that contract gets $1. If the Cardinals win, anyone who owns that contract gets $1. The prices are listed depending on what the market thinks will happen. So a contract trading at 62 cents means that traders think there's about a 62% chance that event happens. If you want to pick the Wildcats and that's trading at 62 cents, you'd buy that contract for 62 cents. If it wins, if you're correct, you get $1 for that 62 cents you had put in. You can buy and sell these at any time before the event resolves. So say the Wildcats are winning, and it's the last couple minutes of the game, the contract might now be trading at 95 cents, and you can sort of cash in before the game ends. Prices move continuously on the free market based on supply and demand. So if a star player gets injured, let's say before the game, the price of the Wildcats contract might drop from 62 cents to 32 cents. When you buy important to note, when you buy a contract on a platform like Kalshi, you aren't buying it from the platform itself. The prediction market platform doesn't bet against you. It just matches buyers and sellers through a central order book and takes a small fee on each trade, the same way a stock exchange matches people buying and selling shares. These people on the other side of the trade on a prediction market can range from people like you and me, institutional traders, or most typical, I believe in current practice, a designated market maker. And market makers are professional trading firms that quote prices on both sides of a contract. They add liquidity to the platforms, and they often profit on the spread between the bid and the ask, so the price that you're being offered and the price that you get, because they provide the liquidity or the money that makes these markets work. On Polymarket's offshore platform, that liquidity provision function is partially handled by an automated market maker, which is a smart contract that uses pooled funds and a pricing algorithm rather than human traders to quote prices. Either way, the platform itself in a prediction market context takes no directional position on the outcome. They don't care who's right. They are just giving you a platform to make these transactions, and they make their money through a small fee or spread on each trade. And that fee is not contingent on who wins. So they really don't care who wins. So when the event happens, say the Wildcats win, everyone who bought the Wildcats contract, let's say at 32 cents, and saw them win would receive $1 per contract purchase. So you're getting your 32 cents back plus the 68 cents that the Cardinals bettors wagered. Basically, you put 32 cents in and you get $1 back. You can buy multiple contracts. So you can buy, say, $20,000 worth of that contract. So now you're getting $20,000 in return for that 32-cent bet that you made 20,000 times. This back end function, remember, so how it works, this central order book, matching buyers and sellers, matching sort of the sort of two sides of these trades, looks like a derivative exchange, not a sports book. And since they are different, it's important to remember that the jurisdictional questions we're covering are limited to prediction markets that are offered via a designated contract market, the marketplace licensed by the CFTC. No one is suggesting, or at least I'm not suggesting, that the CFTC is now the everything regulator for sports betting or gambling. This is where that duck test that was cited in the Kentucky brief, I think, is too simplistic. As Thania Charmani, a partner at Winston Taylor who specializes in litigation, is about to explain.
I think this argument is far too simplistic, and it ignores the reality that the transactions here are structured differently. That matters, and it matters because the courts always look at the economic reality of the transaction, and in that, you look at counterparty risk, you look at how the price is formed here, you look at how the two venues operate differently based on two regulations. So you're talking about two very, very, very different transactions here.
As Thania adds in her answer, and as I've already explained, the operation of prediction markets that are designated contract markets is very different than sports books.
Counterparty-wise, what happens at Caesars is that you bet against the house. The house is setting the odds. This isn't what happens on a DCM. On a DCM, you trade on an open market with a financial intermediary that essentially serves as a clearinghouse, and the price is set by the market. So in a sports book, the customer bets against the house, the book sets the odds, manages its own exposure, and earns an embedded margin. Here, Polymarket or Kalshi doesn't take the other side of this trade. Another participant takes the other side of this trade. Participants trade against each other. And I think this is very important. The platform will earn fees without directional exposure to the event. This is a very different structure than what we see at Caesars. And then I think the second difference, and perhaps the most important one policy-wise, and that goes back to why the CEA needs to protect these markets, is price formation. Sportsbook lines are quoted by the house, while prediction markets prices are discovered through the interaction of willing buyers and sellers. It's not the same thing. And this matters under CEA history because exchange-traded prices function as price discovery signals, which aggregate dispersed private information. This is extremely valuable. This is the entire rationale for protecting these markets. The Federal Reserve has said so. It's not that we haven't been using Caesars for that because we're too lazy to go state by state. It's because it doesn't serve the same function, because the price is not set by the open market. So I think this is determinative. I don't think the courts can honestly ignore that, although I'll say that the Ninth Circuit is poised to ignore that and didn't seem persuaded by that. But I do think it completely eviscerates the argument that you're regulating the same behavior.
Yeah.
And if you see how these exchanges operate, they obviously operate under a much higher bar than Caesars. They have position limits, daily trading information that they need to make public, financial integrity, customer protection. A lot of discussion lately on how trading of insider information is regulated on these markets. These don't exist in a sportsbook context. So we need to be honest here and realize that the simple argument of, oh, you're betting on whether the Knicks are going to win is just too simplistic to reflect what the statute here is trying to do.
Now, before we jump on to the litigation that we've seen, I want to talk about two related questions. The first is, how does the prediction market make money? I talked about the fees, but how are those fees calculated? And second, who determines the winner or the result of any outcome? And that is by far the more and most interesting question. But first, how do they make money? Well, on Kalshi, their fee is calculated by a formula displayed on the order ticket before you trade, and it's capped at a certain limit. They also disclose their fees on their website, kalshi.com/fee-schedule, which also shares any upcoming changes to the fee schedule. Basically, they use a probability weighted fee formula that is basically just the contract's current price multiplied by 7%, then multiplied again by 1 minus the price, with whatever you get rounded up to the nearest cent. That's the fee Kalshi charges for each contract you buy. And that scales depending on how uncertain the contract is. It's lowest in the extreme percentages, so at a penny or 99 cents, and highest at 50-50 mark. Basically, Kalshi charges a fee proportional to the statistical variance of the contract. For most actual trading on the platform, traders end up paying between 2 to 4% of the bet. If you compare that to a sports book where the implicit sort of spread, or VIG they call it, on the standard minus 110 line, so just the standard line, is about 4.5% of the bet. Kalshi is actually structurally a bit cheaper than the sportsbook on the same outcome. Now, those are fees for taker fees, which is what you pay when you place a market order. It's a bit different if you place a limit order, which is a bit of a less fee. But what happens to those fees? Those fees are given Kalshi. Kalshi takes those as profit. They're also given to liquidity providers that Kalshi has agreements with that are market makers. They also have multiple incentive programs that pay users for providing liquidity or trading volume, and a tiered rebate program that returns a substantial portion of fees to active participants. Now, that's sort of how fees work on a platform like Kalshi. It's not too different on Polymarket, Crypto.com's, Coinbase's, or any of the other prediction market platforms. The second and more important point is, how do these markets resolve? Who is in charge of confirming that the Wildcats won? I mean, the answer is pretty obvious in sporting events where it's clear the Knicks won the NBA Finals after those brutal fourth quarter choke jobs by the Spurs. They got to call some timeouts. You got to change up the lineup. Anyways, it's a really difficult question to determine what actually happened. For example, there was a question during the Super Bowl as to whether the musician Cardi B would perform with Bad Bunny. She was seen dancing at halftime, but she didn't sing and clearly wasn't, quote, what I'd call a performer. Yet Polymarket resolved it to yes, whereas Kalshi resolved it differently, as Dustin Gouker, an online prediction market commentator whose Event Horizons newsletter is cited often in court cases, will explain next. Here's Dustin.
Yeah, I mean, this has to get buttoned up if you're the prediction market industry, because we have Polymarket resolving this to, I believe they resolved it to yes, that Cardi B, quote unquote, performed at the halftime show of the Super Bowl. Kalshi did this half measure where they like closed it and resolved it at 26 cents for no, then 74 cents for yes. And there's different ways of doing this. Polymarket uses the oracle that go like they to resolve everything. Sometimes it's straightforward, sometimes it's not. It wasn't as straightforward for that one. But that's Polymarket International, which is on chain and not really regulated in any kind of meaningful way. And then you have Kalshi and CFTC regulated markets where, you know, they're putting up market, a human is resolving it. Usually the rules are airtight enough that it's very clear who won. But in this instance, like the market for who quote unquote performed at the Super Bowl was very ambiguous. I mean, it wasn't at all clear. They said dancing resolved both yes and no, right? I think everybody looked at it like, you know, Cardi B's dancing, right? She's on the screen. She's on this little bodega for under the Bad Bunny concert at halftime, and she was dancing. But Kalshi wrote, obviously, I think, pretty bad rules that said dancing resolves as yes performing. So you can see how people got pissed and confused about this. And to be fair, like Kalshi's putting up thousands of markets. Writing rules that are airtight is not easy.
Before we compare how Kalshi handles resolving these markets to Polymarket, a quick sidebar to talk about the insider trading concerns here. What if someone on the Bad Bunny dance team made a bet on whether Cardi B would perform? What if they knew whether or not she'd perform? Is that insider trading? How would a platform like Kalshi police this? I asked that question to Bobby DeNault, Kalshi's head of enforcement and the Eagles fan I mentioned earlier, who promised me, and I honestly agree, that Eagles fans are really nice people for the most part, so long as, at least I'd say, so long as you're wearing a Brian Dawkins jersey. Anyways, here's Bobby on how they police these markets to ensure insiders don't game the system. I also asked him what would happen if you were just waiting outside the stadium. You weren't necessarily a dancer, but you did your own market research. Here's what Bobby said.
It's definitely a lot to think about. And there's varying degrees of difficulty and complexity that overlay on the question. The Super Bowl halftime question has been this like proliferated hypothetical because there was a lot of people talking about how those markets work and how would policing them work. It is, I think you start with transactions at any financial exchange. We can talk in the abstract about who would or wouldn't qualify as an insider. But one thing from the inside is that, okay, if you're going to hypothesize that there's an insider in the market, point me to the transaction where someone did exceptionally well in the market we're talking about. We get lots of conjecture on social media about how would you what about an insider in this market? I'm like, well, the person who's most profitable in that market made $100. So if you think we should spend our time hypothesizing about a potential insider in a market that yielded someone a $100 profit, it feels a little bit like it's a misguided use of everybody's time. But I do think in terms of starting with the transaction, as a company that KYCs all of its customers because we're governed by federal regulation, and by KYC, I'm sure most of your listeners are lawyers or legal, so they know what it means. But of course, it means know your customer. So we collect their IDs, we collect their name, their date of birth, their address, their SSN, and in some cases, documents from them like a driver's license or a passport. And you start with a transaction that's linked to a person, and you can look at that, the information you've collected about that individual and information you can collect from third-party sources and vendors and things like that, and determine if there was someone who had access to information that might have made it illegal, what would they look like here? They would be an employee of some sort of entertainment agency or a dance company, or they would be working with Bad Buddy. They'd be working with the NFL. And that information is not just like out there in a lockbox. There's so many resources, both public resources and private resources, that can be utilized when you have customer information to develop profiles of people who could qualify as insiders. And I think where you bring up the analogy to the person who happens to be in the area or doesn't happen to be there, goes to the area of the stadium and is listening from the outside, and they hear someone practicing a routine, that's not non-public information, and it's not information that you have some duty not to trade on. That is research in the same way that's, sitting outside a port in Baltimore and seeing how many ships are coming in and out might give you an information edge on, a trading volume in a particular industry. So, there's lawful information asymmetry, and then there's insider trading and unlawful information asymmetry. And I think, yes, it's complicated to talk it through, but it's not as convoluted as I think some people who are all ginned up about prediction market insiders say. And one example we hear on the news occasionally is like, what about the guy in the hotel lobby who hears the CEO practicing the speech and trades on the mention markets or something like that? That same person is not bound by trading on the stock market. They're not an insider. They're a hotel person in the lobby. If there's a big announcement coming from that CEO, they can go trade on that corporate stock. They're not bound by any agreement to not do that. And in the event that they have an NDA, guess what? That NDA governs their trading on a prediction market the same way that it overlays on the stock market. So, it's complicated to talk through, but I don't know if it always presents the complexities that the naysayers suggest that it does.
Now, insider trading aside, Kalshi and Polymarket handle the resolutions of these contracts differently. On Kalshi, they use a centralized resolution committee with internal rules. Polymarket uses UMA, which is a decentralized oracle, which just means the resolution depends on a token holder vote. But what's an oracle? Here's Jeff Amico. He's the chief operating officer at Gensyn and a former partner at A16Z, to explain how an oracle works in the prediction market context. He also shares some really interesting history on how prediction platforms like Polymarket resolve these types of disputes.
It's basically the service that connects real-world information to blockchain environments, smart contracts, so that you can use smart contracts and build apps that, kind of take in real world data and make decisions or actions based on that. In the prediction market context, it's a particularly hard challenge because the benefit of prediction markets, the maybe the core value prop is they can cover all sorts of real world events. They're very expressive. They allow you to take positions on very, very fine-grained outcomes. They allow you to hedge. They allow you to build interesting portfolios of things, much, much more nuanced than you could get just trading on stock markets or bond markets or trading futures beforehand. That's also the challenge, though, in this context, right? Because you're dealing with events that are more unstructured. They're more uncertain. Sometimes there's judgment involved in whether they resolved one way or the other way. And so you need a mechanism to decide, did the event happen or did it not happen, essentially? There's different approaches to this, right? At the one end of the spectrum, you have something like Kalshi, which is fully centralized prediction market platform. They create all the markets, they settle all the markets, they resolve all the markets using some internal team. Totally reasonable approach. Somewhere in the middle, you have Polymarket, I would say, which is kind of a hybrid. In that case, there's history here where Polymarket started out running a fairly centralized version of this. They were creating all the markets, they were settling all the markets. If there were questions, they had an internal counsel that would resolve the disputes. They ended up getting in trouble with the CFTC back in 2022. And as a result of that, they did a couple things. One, they stopped serving US people because they didn't have a DCM license and they were operating a centralized service, essentially. The second thing they did was they decentralized certain parts of the platform as well. So they outsourced the dispute resolution and settlement service to a system called UMA. So UMA is an Oracle service that uses token voting to decide whether or not a given outcome happened.
Now, we've also seen another difficult question on the topic of resolving prediction markets when MicroStrategy, the firm run by Michael Saylor, who famously said he would never sell his Bitcoin, sold some Bitcoin. Here's Jeff Amico, again the chief operating officer at Gensyn, to explain that situation.
So this is kind of like an ongoing market that Polymarket runs every single week. The question is, will MicroStrategy sell Bitcoin during this week period? And it just kind of refreshes every single week going forward. The question for this market was basically what you said. So did MicroStrategy sell Bitcoin during that period? And I think the period was May 26 to May 31, so last week of May. It turned out that they did, that they sold 32 Bitcoin during that week period. The announcement of that sale didn't come until June 1st when they filed an 8K saying that they had sold Bitcoin during the prior week. So the issue there was if you were participating in this market, you're trading in the market, and you do a plain reading of what the criteria said, then clearly the answer should have been yes. In reality, what ended up happening was someone essentially disputed the outcome. It went to the UMA voting system. The voters essentially decided that the outcome should be no because the announcement wasn't made during that prior week period, even though the UMA voting process stretched out 4 or 5 days into June. So it's not as if like it was just a timing thing per se, because they had 4 or 5 days to look back, look at all the evidence, look at the SEC filing and say, yes, the sale did happen during that. If you're reading just the criteria of this market, we should resolve yes. They didn't do that. A lot of people were really upset that they basically didn't follow the plain reading of the market. And there was real money on the line. I think that market was $80 million or something in volume. So a lot of people really lost a lot of money and felt upset about it.
Now, before we move on, I wanted Jeff to explain a little bit more about Polymarket's UMA voting system and how it works. And here's Jeff to explain that.
In most cases on Polymarket, those markets will just resolve normally. There's no dispute. However, there is an option for any user, any participant to dispute the way that settlement was proposed. In that case, you go through a step or a series of kind of stages where there's essentially a second stage where someone can dispute the proposed outcome. And if that happens, then the decision goes to this external service called UMA, where UMA token holders will deliberate, they will discuss the question on forums, and then after a period of 4 or 5 days, usually, they will come back, they will vote on the outcome, and they will decide yes or no, this thing happened or it didn't. And then that decision is binding on the poly market in question.
For more on how these markets resolve on a platform like Kalshi, you can actually go to Kalshi's platform. You can see each market. And if you click the terms and conditions, they explain how each market resolves. So now hopefully you understand a bit more about how prediction markets work, including the fees and how outcomes determine. Let's go over to that litigation. And one of the most important cases is the Ninth Circuit case. This is Kalshi, Crypto.com, and Robinhood against the Nevada Gaming Control Board. Nevada won at the district court level, and the federal district court denied preliminary injunctions to all three platforms, finding that the Commodity Exchange Act does not displace state gaming regulation over sports-tied contracts. They held an oral argument in this case in April of 2026, where a 3-judge panel reviewed this case, and we're likely to get a decision on that likely later in July, maybe August. But as of today's podcast, we haven't got a decision. Now, one of the most important cases happening is the Third Circuit case, which primarily addressed whether sports event contracts are swaps and whether the CEA's, the Commodity Exchange Act's, exclusive jurisdiction grant preempts state law. So whether or not the CFTC actually has exclusive jurisdiction here and state law can apply. They found in favor of prediction markets and the CFTC here saying that it does. Now, the Ninth Circuit panel also engaged with that, but not as much. They were more focused on the special rule, Rule 4011, which seems to, at least they found, prohibit platforms from listing sports contracts in the first place. Now, if the Ninth Circuit rules for Nevada and you have the Third Circuit ruling for prediction markets, and remember, these are both federal courts, now all of a sudden you're going to get a circuit split, and that's what makes it more likely to reach the Supreme Court, and a review for that could come in the fall of 2026. We haven't touched too much on the Third Circuit case, but I want to fix that now. Here's Stefan Schropp. He's the Senior Regulatory Counsel for Paradigm, to explain what he considers the most important legal case on the topic of prediction market jurisdiction.
I think there's two cases to watch right now. I think the first is the case out of the Third Circuit, which is important for a couple of reasons. First, that court oversees New Jersey, Pennsylvania, Delaware. They were also the first federal appeals court to issue a ruling on this topic, right? So it is in some ways the most advanced case, or the case that's farthest along. I personally, from sitting in my seat, think it's the most important because it came out squarely in Kalshi's favor. And I think really didn't struggle with some of the questions that we've seen other courts struggle with, right? So it had very little trouble concluding that an exchange traded swap, a contract that's listed on DCM, is subject to the exclusive jurisdiction of the CFTC, which is something, we've been beating around in various courts. They also had no trouble concluding that sports contracts are associated with potential economic or financial consequences, which is what the statute requires. I thought it was a good down the line ruling from the Third Circuit, and obviously the first federal appeals court is going to be important. And then lastly, New Jersey's pretty clearly signaled, I think, that they're going to seek Supreme Court review of that decision. So I think it will be probably the first case that in a formal way lands on the Supreme Court's docket. Now we'll see if they take that up or wait for a different case, but that's the first one I'd flag. The other case is the Sixth Circuit case, which is set for oral argument later this summer. That's a consolidation of two cases, one out of Tennessee, where Kalshi won below, one out of Ohio, where the state won below. The CFTC also recently asked for time at oral argument, so you'll get the prediction markets, the CFTC, and the state governments arguing, and it's got a good mix of issues as well. And I do think if the Supreme Court doesn't take up the Third Circuit case, the Sixth Circuit case is a good vehicle for a number of reasons to be the one that lands at the Supreme Court.
I asked Stefan to quickly expand on what happened in the Sixth Circuit case, since we haven't mentioned that case yet in this podcast.
The state of Tennessee issued a cease and desist order, at which point Kalshi filed for an injunction against an enforcement action. That's a path we've seen a number of the prediction markets, including Kalshi, use repeatedly when they get a cease and desist order, so that they are in federal court as opposed to state court, which is where the prediction markets, I think, prefer to be.
Before we talk more about the Ninth Circuit case, Stefan made a really interesting point that prediction markets prefer to be in federal court as opposed to state court. Here's Stefan Schropp again to explain why prediction markets prefer federal court to state court.
I'll preface this with there are great jurists both on the federal bench and on state court benches throughout. There's certainly no disparagement, but I think you're exactly right in that, even going back to, kind of core litigation principles, we recognize that there is a possibility that state courts could be biased, one, against out-of-state litigants, and two, again, in favor of their own state parochial interest. And for the true legal nerds out there, there's a thing called diversity jurisdiction, where if I'm from one state, you're from another, and you sue me in your state, I can take that to federal court because there is that inherent risk that they would be biased in favor of the person who lives in the state. And I think that's right. In this context, and I think that's a valid concern, right? And you raised judicial elections as well. Again, there's nothing untoward about it, but we do see the gaming interests are active in all types of elections, and there could be some conflicts there as well. So there's that reason. I also think the core questions here are what we would call federal questions, right? There is the question of, does the CFTC have exclusive jurisdiction under a federal statute and the U.S. Constitution to regulate these prediction markets, or do the states get to be involved? And when you have those types of federal questions, certainly, again, not that state jurists are not well qualified to do that, but this is what federal courts do. They deal with federal statutes and questions of federal preemption on a much more regular basis than the state courts. So I think that's why you see almost all of the prediction markets trying to be in federal court when they can.
As for that Ninth Circuit case, which, to be clear, when I say the Ninth Circuit, Third Circuit, Sixth Circuit, we're talking about the U.S. Court of Appeals, the federal court. The trigger was a cease and desist letter from the Nevada Gaming Control Board in early 2025. Now, Nevada has been one of the most aggressive state regulators against prediction markets, partly because such a significant portion of the state's general funding depends on gaming revenue, particularly from sports betting, more than any other jurisdiction in the country. State officials at oral arguments said that gaming revenue accounts for like a third of the general fund for the state of Nevada. So there's big money at play here for the states. Now, this Ninth Circuit panel, they went deep on whether CFTC Rule 40.11, the special rule itself, prohibits these contracts, these sporting event contracts from being traded. Now, as a reminder, the special rule prohibits any CFTC registered exchange from listing or accepting for clearing any contract that, quote, involves, relates to, or references, unquote, gaming. We've also got an update from that rule, as the CFTC has issued proposed rulemaking that would adjust it to clarify or modernize what it says. Before I get into the proposed amendment, it's important to recall the history behind it, because when we talk about modernizing rules, we need to look at the history about when they were tabled. Here's Brad Bourque, Policy Counsel at Hyperliquid Policy Center, who I'm grateful to have as a sponsor of the Law of Code podcast. And the mission and the reason I accepted them as a sponsor, because the mission of the Hyperliquid Policy Center is to advance a clear, regulated path for Americans to access on-chain markets. That's a mission I personally align with, because greater efficiency can be a win for everyone. But rather than just sponsor the episode, Hyperliquid Policy Center adds tremendous value to the podcast by sharing the expertise of their talented team like Brad. Here's Brad, again, to explain more background on the special rule and how the 4011 rule differs from what's actually in the statute. It's probably the most important point we haven't yet covered.
I think it's helpful to understand kind of where the rule comes from in the first place. So Dodd-Frank, when it was passed, added what's called the special rule to the Commodity Exchange Act, which is codified at Section 5C, which is quite a mouthful. But what the special rule does is it gives the CFTC this additional discretionary authority that it can exercise if it determines that certain event contracts involve, and involve is a really important term, certain enumerated activities if they find that they're contrary to the public interest. And the contract that receives that determination therefore cannot be listed or cleared through a registered entity. So a DCM can't list it, a DCO can't offer clearing services for it. And kind of the 6 enumerated activities that can bring a contract in scope of this rule are activities that are unlawful under state or federal law, terrorism, assassination, war, and gaming, which is particularly relevant right now. And then there's kind of one other provision that's a catch-all that allows the commission to further define other types of activities that could be within the scope of the rule. So a few notable features about the special rule is, one, the statute says that the CFTC may determine. So it's a discretionary authority. It's not some sort of de facto ban. It also authorizes review only in connection with the listing of contracts, which puts this temporal constraint on when the CFTC can actually exercise that authority. So it doesn't authorize things like the CFTC just to make a blanket determination that some kind of event contract can't be listed. It has to be after a DCM has listed a contract, then they can authorize this review process. And importantly, the statute doesn't define some key terms like involve or gaming, which we'll talk about in a little bit, are both terms that this rule starts to try to define. So after Dodd-Frank added the special rule, the CFTC adopted Regulation 4011 in 2011. And 4011 is, how the CFTC implements its authority under the special rule, but it differs from the statute in a pretty material way. The way that it reads is that it says a registered exchange or registered entity, quote, shall not list for trading or clearing contracts that involve these enumerated activities. And so when you read that, there's kind of, a natural reading of it that suggests that this operates as a de facto ban on any contract that, references or involves one of these specified activities. And so I think the proposed rule is important in a few ways that I'll get to in a second, but just for a little bit more background. The commission's used this authority under the special rule 3 times since it was enacted. So in 2012, an exchange called Nadex listed election contracts, political election contracts, and the commission decided to review those under the special rule. They ultimately determined that those contracts did involve gaming, and the way that they were interpreting gaming at the time was effectively to look at the contract as a whole and to look at the act of trading in the contract. And they compared that with state court or state law definitions of gambling, which effectively say, it's the staking of value on any uncertain future outcome is kind of a way that a lot of states define wagering or gambling or the like. And so they looked at the act of what trading these political contracts would be. And they said, well, that looks a lot like gambling. And so we're going to say that these are gaming under the special rule. And then they went further and found that they were contrary to the public interest because they served no economic purpose. They determined that there was really no hedging utility to be gained from allowing these contracts to list, that they could potentially have, perverse effects kind of in the political climate. And it issued an order prohibiting the listing of those contracts. Fast forward to 2020, 2021, ErisX, who's another exchange, listed what they were calling NFL futures contracts at the time. And so these were sports-based event contracts that would settle based on the outcome of NFL games. They had some special things. They were going to limit it to certain categories of participants. They weren't going to be widely accessible. But the CFTC, nevertheless, decided to initiate this review. And ErisX ultimately ended up withdrawing the contracts before the CFTC could issue an order. And so we didn't get to see the final determination, but many of the commissioners put out statements that indicated the CFTC would have disallowed these contracts as contrary to the public interest on the grounds that they involve gaming, kind of using the same theory of if you're trading in the contract, it looks a lot like gambling. And then the final time was most recently with Kalshi's congressional control contracts. This was the actual order that disallowed Kalshi from listing their political contracts leading into the midterm elections. Kalshi sued in the district court for the District of Columbia, and the court ultimately overturned that ruling from the CFTC. It gave a pretty long opinion that went into some of the definitions of gaming and involve, and is really, I think, influential in this rulemaking. It was the most public use of the special rule authority at the time. And as we all know, the political contracts trade today. So it's kind of a little bit of background on the special rule and how it's been used and operationalized.
Now, that was a bit more than a little background, Brad. Thank you so much for that explanation. I think that that's such important history and so much of it that we hadn't touched yet in the podcast. The special rule is particularly important given what's happening in the Ninth Circuit case, where the rule is at the core of litigation, and it seems like the state of Nevada, at least the Gaming Commission, is going to beat prediction markets in that lawsuit. It's also important because of recent CFTC proposed rulemaking, which we'll explain shortly. I'll let Brad, again, the policy counsel at Hyperliquid Policy Center, explain why the CFTC proposed rules relating to the special rule are so important.
And the reason that the proposal from the CFTC this week really matters is I think there's two reasons. One, it really provides a lot of clarity to market participants. It's the first time that the CFTC has come out and said how it intends to apply the special rule. So you get these key definitions of what it means for a contract to involve an enumerated activity. We get a definition of gaming. We get codification of these, transparent list of factors that the CFTC will consider in the public interest review aspect of the process. And it sets out this clear 100-day timeline. So it can provide some certainty when an exchange lists a contract about what it's going to look like if it does get roped into the review process. The other reason why the rule is really interesting is because how it intersects with the ongoing litigation in prediction markets right now. So we have all these cases with states and tribes suing both exchanges. We have the CFTC involved suing some states. And kind of a core argument that the states and the tribes have been making gets back to the special rule and gets back to 4011, where they're basically saying the CFTC, through the adoption of 4011, prohibited these types of contracts. They prohibited gaming contracts. And if you're listing sports-based event contracts as a DCM, the states say you're in violation of the law. And so those are illegally listed contracts. And not only are the DCMs violating the law in their view, but also the CFTC is abdicating its statutory duties by not enforcing its own rules. So I think this rule will it really does a lot to undermine those arguments in litigation. And more broadly, it really is the CFTC coming out and saying, these contracts, including sports-based contracts, fall squarely within our statutory authority. They're within our exclusive jurisdiction. Here's how we plan to regulate them. And the message for the states and the tribes is really that Congress knew that there might be problematic event contracts. And Congress's answer to that was to provide the CFTC with this special rule authority, not to allocate jurisdiction to the states or the tribes when it comes to these contracts. So I think it really undermines a core argument that's playing out in the litigation right
now. It's about time I explain what those proposed rules are, right? Well, on June 10th, 2026, the CFTC published a notice of proposed rulemaking seeking public comment on amendments to CFTC Regulation 4011, the special rule. There are 5 key clarifications, I'd say, that relate to the special rule. And here are 3 important points that are highlighted by Gary Kalbaugh, a partner at Cahill, via the Cahill Next blog prediction market update. I'll link that in the show notes below. First, the proposal does not ban contracts on politics, sports, or other sensitive subjects. Falling into one of the 5 categories, remember these are those 5 categories, gaming, terrorism, etc., that trigger a discretionary review. And the CFTC decides each contract case by case on public interest ground, which is kind of exactly what the statute says they should have been doing this whole time, because the language in the statute is that they may determine. The second point, contracts on the outcome of professional or college sports, like final scores, win-loss records, season statistics, with objective criteria, significant surveillance, and coordination with sports bodies. The CFTC has a memorandum of understanding with the NHL, for example, are generally ruled favorably. But contracts tied to discrete in-game events like player props, player injuries, officiating, youth sports, or pure chance are likely to be found contrary to the public interest. So the CFTC isn't opening the window for gambling here. They're just saying, hey, certain event contracts that we can really monitor well can fit into these event contract definitions. Others don't. We're not trying to regulate all gambling. Now, there's also a really important point around the word involve. Now, Dodd-Frank lets the CFTC act only when a contract, quote, involves, unquote, one of those 5 categories, gambling, terrorism, etc. And that single word has driven years of litigation because the statute left it undefined. What does it mean for something to involve gaming? So the proposal looks to clarify that. The proposal recognizes we need some clarity here. They say a contract involves a category only if the event that decides who wins is itself one of the categories. It rejects the broader theory that trading on an outcome is itself a form of gaming and moves a larger set of contracts outside these enumerated contracts. So it's a bit complicated, and honestly, like, I'm a little confused over what that means, and you probably are too. Actually, you're probably not. You're definitely super smart on top of this. But I didn't really understand this, so I asked Brad Bourque, policy counsel at Hyperliquid Policy Center, to expand a bit more on the term involved and how it operates here.
There was a lot of uncertainty before about what it meant for a contract to involve the activity. And what they've decided on in this proposal is that really involve is tied to the settlement trigger. And so they say that a contract involves an enumerated activity only if its settlement is determined by an occurrence inside that activity. And so I think a helpful example to illustrate how this might work is thinking about the war prong, for example. So like if you had a contract that settles based on how many ships pass through the Strait of Hormuz in a given month, that contract would not involve war, even though a war in the region could affect the number, because the settlement trigger is the number of ships. Whereas if you had a contract that said, will X country launch an airstrike in the region by X date, that's something that where the settlement is whether the airstrike occurs. And so that's something that is going to involve war. So like that idea of the centrality of the settlement trigger is really how they're going to determine whether a contract then gets to the public interest review phase.
So taken together, these three moves do something that none of the prior CFTC actions have done. They give prediction markets a workable framework. Here's Brad Bourque, again, policy counsel at Hyperliquid Policy Center, to explain how this three-part framework would work in practice.
Yeah, so the total framework, there's three specific steps. The public interest review being the last one. The first, just as a threshold matter, is to determine whether this is even a type of event contract that is kind of subject or within the scope of the special rule. And so the special rule applies to event contracts that reference excluded commodities. So there's kind of that threshold determination of, are we talking about an event contract that fits within this framework? And then the second step is determining whether that contract, quote, involves one of the enumerated activities. And there was a lot of uncertainty before about what it meant for a contract to involve the activity. And what they've decided on in this proposal is that really involve is tied to the settlement trigger. So then the third step in the review process is in whether a contract that involves enumerated activity is contrary to the public interest. And so what the CFTC has proposed is to codify these lists of factors that they'll consider. And there's kind of two buckets of factors. There's three of them that will apply to any contract that's eligible to be reviewed under the special rule. And then they also have additional factors that are specific to the type of enumerated activity. So it's first you have to go through these three gating factors. None of them are determinative. It's kind of a weighting of the equities approach. And so the things that apply to all contracts are whether they have informational or hedging utility, which is something that's going to count in favor of the contract listing, whether there's any in-market integrity considerations, including whether a contract has like a particular risk of being manipulated because of the subject matter, whether there's any problems with the integrity of the settlement source, or if the contract is like structured in such a way that it encourages insider trading. And then the final kind of general factor they'll consider is whether the contract in any way impairs the exchange's ability to meet its compliance obligations. So if it, for example, it's difficult to ascertain like who might be trading in the contract or where they might work or that kind of thing. If there's a particular risk, it would cut against the exchange being able to list it. Then there's the activity specific factors. These are pretty long and they're pretty, tailored to the different types of activities, but they are mostly reflect like these common sense principles. They have to weigh the factors in both directions, explain the reason, the agency's reasoning, and then, if applicable, kind of square a decision with a prior decision they've made based on similar subject matter.
Now, let's talk about the proposed public interest test. The proposal lists out a set of factors that the CFTC will weigh when conducting a public interest review of a contract that involves gaming and all the other enumerated categories. We'll just focus on gaming here. The proposed rulemaking sets up a multi-factor public interest review that also considers information utility, market integrity, manipulation risk, and the exchange's ability to surveil the market. Here's Stefan Schropp, Senior Regulatory Counsel for Paradigm, to explain why this is an important step in the right direction.
What prior CFTCs had done is draft a rule implementing that statutory provision that frankly was not a model of clarity. I think it's engendered significant confusion. If you've listened to any of the oral arguments, you've heard of Rule 4011 or 40.11, and you've heard, I think, good faith, but very contrary readings of how to interpret that rule. And so what the CFTC has done here is it said, okay, we're going to put the public interest determination front and center like the statute said it should, and we're going to give you clear guardrails and clear parameters and factors that we're going to look at when we're making that determination. And as I think we've all agreed at this point, under this rule, gaming involves sports. Now sports are defined to be included within the enumerated activity of gaming and will be subject to this public interest determination. And then the CFTC has laid out factors that it thinks counsel in favor or against, nonetheless listing that activity because the public interest outweighs the drawbacks of listing that contract.
Now, these factors are split into two buckets. First are three general factors that apply to every contract that gets reviewed under the new framework, regardless of what enumerated category, whether gaming, terrorism, etc., they fit into. So the CFTC will weigh three things. First, the contract's price discovery and information aggregation value, the threat it poses to market integrity. Can people use this to try to corner the market like we've seen in things like onion futures in the past? And three, whether the exchange has the operational capacity to administer it. The CFTC also gives specific guidance for the gaming category. Games of pure random chance, like a contract on a roulette spin, are likely to be rejected because they serve no legitimate purpose. Sports event contracts get more nuanced analysis with two sets of factors. Contracts that we've mentioned before, contracts that settle on aggregate, objective, independently verifiable outcomes like the final score, season-long stats, are favored, whereas contracts that are on single events, sort of one-off plays or a referee's call are disfavored because they reduce the outcome to a handful of identifiable people and invite manipulation. Because remember, the CFTC has rules around market manipulation that they need to enforce on all their designated contract markets, which is where these prediction markets sit. Here's Brad Bourque, again, Policy Counsel at the Hyperliquid Policy Center, to explain at a high level how the CFTC proposed rulemaking illustrates the Commission's interpretation of the statute and solves a problem with interpreting Rule 40.11.
The problem with the way it used to be interpreted, which this is what the court in the Kalshi opinion reasoned, was if you interpret gaming in the super broad way about the contract, it essentially swallows the rest of the rule. Because then if you have a contract that's referencing assassination or war, you're still staking something of value on an uncertain outcome. So it would be silly to have the rest of the categories if they were all prohibited under the gaming definition. And courts generally assume that Congress doesn't mean to add provisions to the statute that don't mean anything.
What Brad explained there is really important because if gaming already captures every contract where money is staked on an uncertain outcome, the special rule didn't need to separate terrorism, assassination, and war because they already all would be gaming under that broad reading. This is the same argument that a judge relied on in a 2024 decision overturning the CFTC's prohibition of Kalshi's election contracts. And let's talk about that decision now, because it's arguably the most important court decision to date that led to everything that we're seeing today. So in June 2023, Kalshi, which was already licensed as a designated contract market by the CFTC, self-certified, which is what designated contract markets can do. They can sort of say, hey, we've reviewed these meet all the criteria that the CFTC has for what a DCM should do. They self-certified 2 event contracts, asking whether Republicans would control the Senate and whether Republicans would control the House after the 2024 elections. Now, the CFTC opened a review of that under Rule 40.11, under the special rule, and they found and they issued a final order prohibiting Kalshi from listing those contracts. What did Kalshi do? Rather than roll over, Kalshi said, wait, we should be able to list these contracts. So they sued in the U.S. District Court for the District of Columbia in 2023, challenging the order under the Administrative Procedure Act. About a year later, Judge Cobb vacated the CFTC's order, agreed with Kalshi, and when the CFTC sought an emergency stay, so they tried to get an emergency pause, the three-judge panel disagreed and denied it. So Kalshi began listing election contract markets within days, and the November 2024 election cycle produced hundreds of millions of dollars on Kalshi's market. Now, that was a landmark win for prediction markets, and I spoke to Dustin Gouker, an online prediction market commentator who was previously focused on gambling and who has an Event Horizon newsletter that's been cited often, for an earlier episode of this podcast about what happened and why this came on his radar.
Fast forward to, I started seeing it like late 2024 when we saw election betting kind of come up. Obviously, in retrospect, Kalshi was being sued by the CFTC. CFTC under the Biden administration did not want them to be offering trading, betting on elections. I'm going to use those interchangeably because I'm not a lawyer, but they didn't allow trading on this. They went to court about it. In October, I believe, of 2024, an appellate court actually said, hey, Kalshi, you win. You should be able to have election betting. So it opens up this huge new world for Kalshi, which had been a pretty small player in everything until that point, offering regulated election betting in the United States, all 50 states. And then things kind of take off. It still was just kind of on my periphery until like December of that year when Crypto.com self-certified markets on sports event contracts. I was like, oh, that's interesting. And that's kind of big. So I started like, oh, I really need to start following this more closely. Kalshi, of course, starts self-certifying football contracts, including the Super Bowl of 2025.
Now, we haven't spoken about Crypto.com much in this podcast, but they set a significant precedent by self-certifying markets on sporting events, and they had a licensed DCM that they had purchased. I do want to give a quick shout out to Crypto.com's chief legal officer, Justin Wales, who is an exceptional lawyer and maybe a better person. He sent me the coolest thing I've ever gotten in the mail, which is a pop Funko of myself holding a microphone and a football. Now, if you're watching the video version of this podcast, you can see it here. I'm just holding it up to the screen. It's pretty cool. You can see there's the microphone and the football. Anyways, really, really cool gift. Thank you, Justin. Shout out to Justin for that one and all his work at Crypto.com. So anyways, speaking of Crypto.com, it was Crypto.com's listing of the sporting event contracts that really got this whole ball rolling, because Crypto.com had bought NADEX, the licensed designated contract market, to integrate into the prediction market space. And it was there that they were listing these sporting event contracts. And this was a huge shift in how people recognize the rules of sports betting to apply. Now, the most important rule around sports betting was PASPA, which was the Professional and Amateur Sports Protection Act of 1992, a federal statute that effectively banned legal sports betting in the United States. During the time that sports betting was illegal, the 26 years, the American Gaming Association estimated that Americans wagered $150 billion per year on sports illegally, with virtually all of it flowing through unregulated offshore channels. The result was a huge underground market that didn't pay taxes, that operated outside of any sort of consumer protection framework, and was widely thought to be a source of revenue for organized crime. That's not good. And so thankfully, we started to see some of this coming back onshore in 2011 when New Jersey passed a referendum permitting sports betting by amending its state constitution. Obviously, that led to Major Sports League and the NCAA suing to block the law, arguing that this was in violation of PASPA. This case eventually got to the Supreme Court in the case Murphy versus NCAA, which was originally called Christie versus NCAA and renamed when Governor Chris Christie left office. The Supreme Court struck down PASPA, saying that Congress can regulate sports betting itself, or it can preempt state laws, or it can attach conditions to federal funding to induce states to take certain actions. But Congress can't just order state legislators to not pass a particular law. And so the court found PASPA to be unconstitutional. Now, in the next clip, and PASPA history is very important here, as Daniel Wallach will explain. Daniel Wallach is the sports betting and gaming lawyer who founded the firm Wallach Legal LLC. He's an invaluable follow to stay updated on what's happening in the prediction market space. He has made a sharp version of this argument that if Congress had legalized nationwide sports betting through Dodd-Frank, the entire industry wouldn't have spent the next 8 years fighting to overturn PASPA. Here's Daniel.
PASPA was unconstitutional because without a federal scheme of regulation or deregulation, PASPA was nothing more than a direct prohibition placed on the states without the federal government supplying a scheme of regulation or deregulation. That's what PASPA was unconstitutional. That's why New Jersey won. And the argument being advanced by Kalshi today not only would nullify the reasoning of Murphy versus NCAA, but it would have been a complete shock to everybody to find out that there was a sports betting regulatory scheme that existed in 2010.
Now, the sportsbook industry that sprang up after Murphy versus NCAA is slightly different than prediction markets. The CFTC is not trying to regulate sports betting. They're just limiting their involvement to the prediction markets, that the same markets that they'd spoken to the Iowa researchers about in the 1990s, only expanding the scope of what's permitted to modernize it to include sports event-related contracts. Thania Charmani, a partner at Winston Taylor, is about to explain why the argument that the CFTC is trying to displace sports betting or gambling itself isn't true.
I think it's slightly misrepresenting the text of the CEA and the argument that the exchanges are making before the courts to say that they're taking the position that Congress intended for the CFTC to regulate gaming. This is not what they're saying. What they're saying is that the CEA granted the CFTC exclusive jurisdiction to regulate transactions on designated contract markets, whether or not the underlying contract involves gaming. So it's not that suddenly the CFTC wants to infringe on the state's rights to regulate gaming. Is that the CEA clearly and unequivocally said that the CFTC will regulate these transactions traded on DCMs, will regulate swaps, will regulate these events contracts. And by the way, in 2010, it added this provision, Section 5, under the Dodd-Frank Act, saying if the Commission believes that these contracts violate public policy, including 5 enumerated categories, naming gaming, the Commission may determine that they shouldn't be listed. That should be the end of the discussion. That's the truth. These cases have one question presented before the courts. Is it the CFTC's job to regulate these contracts on DCMs, even if they involve gaming, or not? And the CEA said, yes, the federal government has exclusive jurisdiction, and yes, the CFTC will control over all of these contracts, even if they include gaming. There is really no good argument based on the text or the history of this legislation that Congress intended for gaming event contracts to be regulated by the states.
As Thania noted, and as I explained earlier in this episode, the text seemed clear that contracts around gaming fall into the CFTC's jurisdiction. And that doesn't mean it's either one or the other. Both can exist on the merits and both can exist under law. Here's Josh Sterling, a partner at Milbank and former division director at the CFTC, to explain that point.
I mean, people say there's this section of the Commodity Exchange Act, Section 2E, that says essentially the particular kind of contract can only be traded by retail persons on a DCM, on an exchange. That is true, but that doesn't mean that a sports book with a sports bet is such a contract. Even the exclusive jurisdiction provision of the Commodity Exchange Act says, except for the narrow category of stuff that's actually on a DCM, state laws continue to apply. In addition, the CFTC and the SEC were required to write a rule, and they did in 2012, that said, essentially, consumer or commercial transactions that are not tradable are not swaps. They're not, therefore, having to be traded by retail persons on an exchange. And sports bets against a sport book are not tradable. And they are something that had traditionally existed, and I think they can continue to exist. So I think they can coexist. I think it's kind of a convenient argument to try and say, well, if you allow this, then there will be no sports books. I don't think that's by operation of law. I mean, maybe some companies would choose to gravitate into prediction markets rather than deciding, brand new to start a sports book or something. That's possible. I don't know. But what I do know is that both can coexist.
As I said earlier, Prediction markets and sports books will have to compete on the merits, as they should. And I think that's a win for consumers everywhere. I asked Matt Kalish, he's the former co-founder and longtime president of DraftKings, now the CEO of Hardscope, whether the traditional sports books, like those DraftKings offers, can coexist with prediction markets. And he had an interesting perspective on the types of people using prediction markets in the future for sports books.
There's precedent for them coexisting already. Like the best example most people point to is Betfair Sportsbook and Betfair Exchange in the UK, which has been around for a bit. And the exchange customer is quite different than the typical sportsbook customer in sophistication. Like you're talking about probably a top 1 or 2% audience is typically in the exchange. You know, vast majority of customers, they're here to play for fun. They have jobs, they have families. At the end of the day, they don't have a bunch of time to build computer systems to trade stuff on an exchange, right? It's, you just want to like click a button, put in a bet amount, get the bet on. Hopefully you get great rewards, great promotions, and enjoy the game, right? There's no time for any of that for most people, the vast majority. And those are the kind of people that sports books were built to serve, right? And then exchanges, much more of a hardcore product. Like there's a lot of things in a sports book that create equity or the same experience across everyone. Like everyone is shown the same price. And an exchange, I think much more nuanced, right? There's all this liquidity, kind of how I got into it initially was running into a wall on this liquidity problem on a bet, right? It was PGA Championship bet where there was a ton of breakage in the market. And I was like, for $1,000 bet, no sports book in the world's not taking $1,000, but like, you can't hold the odds at 1,000 on this product. Like it seemed very weird, like illiquid. And consumers have to figure that out. Like they're going to have to figure that out and it's going to look weird. Almost everybody believes they're going to lose money gambling, right? Unless you're a professional gambler. And therefore it's all about the experience. Like, do you get the best rewards back, the best treatment for your loyalty to a company? And no different than if you go to Vegas and they all have status programs and stuff. People just want to get treated well, knowing that it's gambling. The gambling has a house edge, and that if you gamble long term, you're probably going to lose or get lucky, right? Exchange is very different on that front. It's almost being positioned like it could be a job. It could be you could beat the house. You know, and I think there's a lot of these nuances are getting intentionally conflated by a Kalshi, for example, like not being transparent that, oh, you are betting against the house. You're betting against Susquehanna, Jane Street, professional gambling syndicates who are the best in the world at this. Nothing sitting on the order book when you're scrolling your app. Any of those people think is profitable, right? Like, obviously, it wouldn't be there. They would take it. like if anybody on earth who has any sophistication thinks that that is a good, like, odds to take, it would be gone, right? And it's getting conflated intentionally, I think, to create this, like, sports books aren't as good as the exchange. But if you play it out a few years, I mean, it's going to be 98% of people would much rather use a sports book. And the professional gamblers love the exchange, you know. That's pretty much how it breaks down.
One thing that was interesting to me from our conversation was Matt's perspective on prediction markets. If you just saw his posts on X or LinkedIn, you'd think he was anti-prediction markets, but he's not. His complaints are a bit more nuanced. I asked him if he thought prediction markets should exist at all.
Yeah, I think both should exist. There's a real utility around prediction markets in sports markets, and I would say it's mainly for professional gamblers and Wall Street hedge funds that want to trade and beat each other up and stuff like that. But this is not a nice place for a random consumer, right?
Matt's last point, that this might not be a nice place for a random consumer, is one based on his own experience relating to liquidity as well as who are the actual market makers opposite him on trades. The thing with prediction markets is they provide just as much value for the people not trading on them, who can use the markets to forecast future outcomes. Before we hear more from Matt, here's Koleman Strumpf, an economics professor at Wake Forest, to explain how he benefits from these markets without trading on them.
For people who don't trade in the markets, which I would include myself among those people, because I've learned I don't have an edge against people. Like, I've talked to a lot of traders and they're much smarter than I am, so I'm not going to beat these people. But I can still go to Kalshi, Polymarket, or whatever site you want to pick, and I can draft on all the forecasts that these people are generating with their trades, and I can learn a ton about the world, whether that's about foreign affairs, economic indicators, elections. It's pretty amazing. And to me, it's like first step in my sort of news diet for the day. Go to the prediction markets, see the stuff that's bubbling up, use that as a way of informing what I read in the news.
Again, as I mentioned at the start of this podcast, these markets were cited in newspapers like the New York Times for decades in the early 20th century and late 19th century. Now, as for the user experience and winning on the merits, I mean, that's something I'm guessing prediction markets are addressing because, as Kalshi's head of enforcement, Bobby DeNault, explained at the top of this podcast, these markets are businesses. They need to earn, meaning attract and keep customers. If prediction markets or sports books are to win customers, it should be on the merits, not regulatory modes. And Bobby is obviously a bit biased since he works at Kalshi, but he explains now why he believes in prediction markets.
I think that the product we offer regarding the trading of sports event contracts is a fairer product for consumers. You know, we're not the house. We're not chasing people who are going to lose on our platform. We want people who succeed at trading on our platform. We don't have any stake in whether you win or lose. Individuals trading with one another and having easier enter and exit capability out of their positions and getting competitive pricing and fees and things like that from having more options as a customer in the space around sports. I think that it very much scares monopolies who have had total control over retail access to things that interest them in the sports space. And so they are driving a lot of the messaging about prediction markets being unregulated. I mean, when I hear this, it drives me crazy. If we were unregulated, I don't know if I would have a job. I speak to our regulators probably 3 or 4 times a week, and so do other lawyers at our company. Not just about ongoing investigations, but about lots of things. Our surveillance systems, how we're certifying and listing new markets. I mean, all the systems we have are subject to audit and examination by the CFTC. And the idea that every system at a casino or sports book that's being subject to state regulation is being examined and audited by state and local regulators on a weekly basis. It's not been my experience from hearing people who work in the space, especially as lawyers, that is what's going on. And so I think it's just a total piece of misinformation to do this. Prediction markets are unregulated when in fact, I think we're probably subject to more stringent and rigorous regulation than sports books and casinos.
It's especially important, I think, for people to understand the regulations that apply here, given what's felt like a media blacklist. Here's Bobby DeNault again to explain why he thinks there seems to be some sort of media backlash against prediction markets, which largely goes back to insider trading concerns that we addressed at the opening of this podcast.
So I think anytime you see a new financial product, and we saw this a lot with crypto, there is a knee-jerk reaction to all the ways there might be gaps in that product or exposure to dangerous behavior in that product. And I think a lot of the insider discussion comes from the specific characteristics of the types of contracts that get offered, to the breadth of things that become material to markets that we offer is wider in the sense that our contracts and markets cover more ground than maybe traditional company equities, stocks, et cetera, things that are more traditionally regulated financial products. But I do think that it's a bit misguided to conclude that insider trading is uniquely problematic on prediction markets for a couple reasons, mainly because the first and foremost being insider trading is a pretty serious problem on traditional equities markets. And I think Americans largely feel this way. You can see it in their sentiment about congressional insider trading and people who are very successful at trading in traditional markets. I think that prediction markets make for a bit of a convenient punching bag in some ways, because it's easy to say, well, what about, the insider who's on a TV show and trading on that information? Okay. But the universe of information that's material to that contract is actually a significant amount tighter than the information that's material to the price of a stock moving up or down. And so there is an ability for us as we surveil prediction markets to zero in on, okay, here's a market on the Fed rate announcement for next month. There's really a pretty narrow subset of what's considered material non-public information about that outcome on that contract. Whereas if you're considering materiality to the price of an oil company's stock, there's a whole host of events and information that people might know and have a duty not to trade on that can affect that price going up or down, whether it's production at an oil field or behavior at a port or behavior in the government. And so, I think it is a bit misguided to zero in on these markets as being uniquely susceptible.
Now, to be fair to some of the critics of prediction markets, these markets aren't perfect. They still are figuring things out. As I think they'll readily admit, there's still a long way to go. Some of the areas that need work are probably around messaging and marketing, given how regulated advertising is in the traditional sports betting and even equity space for good reason. Here's Matt Kalish, again, the co-founder and former president of DraftKings, to explain his complaint about the messaging on a prediction market like Kalshi.
So you come in, their whole top of the funnel is getting built off of betting on sports, right? They're tapping into that sportsbook messaging effectively, right? Yeah. Then from there, you land on the app and it looks like a nice, friendly app, right? You click a button, says the odds for the thing you want to bet. And I think I'm playing against my peers. Great. That's awesome. I feel like I can beat peers way faster than I could beat a sports book. Right. I have a better shot, right? My money will last longer if I'm playing peers versus the house, right? And that's not really what happens in the app. The app is like a styrofoam sword against a Valerian steel API that Wall Street is beating your ass with as a recreational user in the app, right? They're first on everything. Anything that hits the order book, they're getting the first look at. They're taking what they want. They're posting in the house edge like a sports book would with their odds that they post. They're capitalizing on crazy angles that would never happen in a sports book, like delayed data feeds, like arbitraging, like in-game or player prop. News comes out, somebody's not playing in the game. That has a massive impact, right? Anybody that has dollars on that, you're not canceling these orders. Wall Street is taking the best side of that. They're adjusting every single other player instantly and taking what they think makes sense, right? Before you'd ever have a chance on the app to adjust it. All that stuff doesn't happen in a sports book, right? You don't worry about that. If you're going in the sports book to make a player prop, maybe the market freezes for 5 seconds and the odds refresh and you see what the price is. You never get stuck holding the bag like that, the way that posting on an exchange does. And Wall Street's going to do that so much better. So much better.
So, yeah, disclosure could be better. As I think an important thing to note is there already is significant care and regulation in these markets. The CFTC has a comprehensive set of rules that designated contract markets, Kalshi is one, must follow, including rules around market integrity, position limits, customer protection, financial integrity, and self-regulation. DCMs are also required to surveil their own markets, prevent manipulation, enforce trading rules, and report data to the CFTC. I asked Bobby DeNault, again, the head of enforcement at Kalshi, how it feels to have some people think that prediction markets could be banned and some people say that prediction markets aren't regulated. It must be pretty frustrating. He is human after all, like the rest of us. And before this clip, I just want you to know that I did explain to him that I thought it was a bad idea to say we should ban anything because of early activity gone wrong. For example, the steam engines, they exploded. When Cornelius Vanderbilt was first putting steam engines on boats, they were exploding, killing a lot of people. Imagine if we banned steam engines. Now we don't have railroads. Now we don't have probably cars. Like the infrastructure that built America doesn't exist without the steam engine. And imagine if a regulator banned it back then. Here's Bobby on the topic of banning prediction markets.
Right. I mean, it's not ever the right solution when you're looking at a financial product and the companies offering that product, like Kalshi, raising their hand and saying, we want to be regulated. We want to handle this the right way. We're building surveillance systems and hiring lawyers like me to police these markets. We're working with our regulators directly. We're happy to take feedback and work together to come up with rules that make sense for these markets. It is crazy to take the position that you should just ban them. It is actually quite rare that you get players in a new financial space that are raising their hand for some very strict and difficult regulations and saying, yeah, we actually think this framework makes the most sense and we're happy to work with you on making sure we're doing a good job at it. It's just not, I don't want to say it's not the American way because it's such a cliche to sort of invoke that, but America is a country of financial innovation. If we become a country that just says, ban it, even when people are trying to say, tell us how you'd like us to regulate it the right way, and we're happy to do so, we will lose our status as financial innovators around the world. And you can bet, and there already are, offshore prediction markets that are unsafe and don't KYC anybody and let anybody who's anybody trade on any outcome. And you may have no idea whether that person is an insider, whether that person is sanctioned, whether that person is a money launderer. Those will proliferate in the absence of regulated prediction markets. So it's I don't really think it's something we have the optionality to say, oh yeah, just ban it all and we'll let it all go offshore.
Yeah, his point about it all going offshore is certainly true, as has been the case with really any financial innovation that has been banned, including prediction markets. As mentioned, Kalshi was approved by the CFTC as a designated contract market in 2020, but prediction markets remained relatively niche until 2024. Polymarket was founded in 2020, operating offshore, exploded in popularity during the 2024 presidential election for a reason Kalshi couldn't match. Well, Kalshi was constrained by U.S. regulation, and they were in that lawsuit that they eventually won. From listing event contracts, Polymarket had no constraint and was able to offer these markets on the most important political question of the year, which was the 2024 presidential election. Anyone with a crypto wallet could trade on Polymarket, and the platform's odds were being cited by major media and news outlets around the world. Polymarket has since purchased a U.S. entity that is licensed as a DCM, but they also still have their international offshore business. Now we're starting to see rules and comprehensive sort of onshoring of these markets and more stringent governance, but that wasn't always the case. The CFTC under the Biden administration moved aggressively against prediction markets on multiple fronts. PredictIt, which launched in October of 2014 under a CFTC no action letter, was operated by Victoria University of Wellington in New Zealand in partnership with the U.S. firm, operated as the dominant U.S. prediction market venue for political contracts. But in August of 2022, the CFTC withdrew its no action letter and ordered PredictIt. I'm going to leave that in there because that's kind of funny. They ordered PredictIt. PredictIt could be a fun name, couldn't it? Anyways, they ordered PredictIt to wind down within 6 months. That triggered litigation. In July of 2023, the Fifth Circuit Court of Appeals reversed the district court and entered an injunction against the CFTC, blocking their wind down order. In 2022, Polymarket was fined by the CFTC and agreed to cease providing services to U.S. customers. 2 years later, the FBI raided the founder of Polymarket's house and seized his phone as part of an investigation into whether or not they were continuing to serve U.S. users. In 2023, that's when the Kalshi litigation came up that we mentioned earlier, where the CFTC tried to block it. They eventually lost in court. Well, in 2025, the political setting changed. The new administration came in, and that changed the agency posture. The investigation into Polymarket was ended. We saw Polymarket purchase a DCM to come under regulation. So whether you morally agree with the hyper-financialization we're seeing in the world or not, this is done under the supervision of regulators. It was happening anyways before. Now it's leading to jobs in North America. It's leading to transparent and enforceable markets. It's leading to well-understood rules with a regulator that sits on top of it. That has to be better than the alternative, right? So we can ban markets or we can make them unenforceable, like we've seen regulators and popes do time and time again. But because demand for forecasting and predicting the future is so large, prediction markets have never truly gone away. A product that existed in the 15th century Rome and continued in modern America is probably here to stay. So we can do the hard things and wrestle with these problems so they are addressed in a fair, honest, and transparent way. I think that's a win for everyone. And that's the mission of this podcast, Law of Code. So thank you for listening all the way through. The fact that you're still with me proves to me and hopefully yourself that you're among the top percentile of thinkers in the world. So thank you for investing the time to properly understand prediction markets. This podcast is part of my mission to help people understand the legal layer of emerging tech so that we can live in a world with transparent and well understood rules applied fairly to all. You can stay updated on new articles and podcasts by subscribing to my free newsletter, lawofcode.fm, so not .com, lawofcode.fm. It's literally the world's shortest newsletter. I haven't even launched it yet, so you'll be one of the first to get it. Now, as you probably can tell, I'm tired. That was a heavy, heavy episode. It took me probably now 120, 130 non-billable hours. I started working on it in January. I'm publishing it in June. I do all the research myself. I coordinate all the guests myself, and then I do all the editing myself. And I'm working to make this a full-time thing. And thankfully, a few sponsors are helping me with that. Thank you to the team, Louis Cohen, Sam Enzer, and the entire Cahill team, as well as the Hyperliquid Policy Center's Brad Bourque and Jake Travinsky for sponsoring this podcast, as well as the Solana Policy Institute for supporting this podcast as a sponsor and for educating policymakers on difficult technologies like how decentralized networks like Solana are important to the future of the digital economy. Obviously, super important. Thank you to everyone who joined me for this episode. That includes Bobby DeNault at Kalshi, to Michael Passalacqua at the CFTC, former CFTC Chairman Chris Giancarlo, Stefan Schropp at Paradigm, Josh Sterling at Milbank, Thania Charmani at Winston Taylor, Daniel Wallach at Wallach Legal, Matt Kalshi at Hardscope, Sam Enzer at Cahill, Gordon and Reindel, Paul Grewal at Coinbase, Koleman Strumpf at Wake Forest, Brad Bourque at Hyperliquid Policy Center, Jeff Amico and Dustin Gouker. Like, that's a lot of people. And they were so generous with their time. They didn't know when this was going to be published. I didn't pay them to join. They didn't pay me for the right to join. I would have had all these people on, regardless of whether or not they were a sponsor or not. Also, I just want to give a quick shout out to the CFTC and to everyone in the regulatory sphere who's really working tirelessly and doesn't get commission or anything to put these rules in place. Like, this is a really hard thing to do, and I commend people who work hard to do hard things. So really, thank you so much for listening. I had a lot of fun doing this. I hope you enjoyed it as much as I did. I predict we're going to be talking more about these markets in the future, so make sure you subscribe for that. I still can't believe I say things like subscribe. I'm not a YouTuber. I'm a lawyer. But hey, here we are. Thanks so much for joining me. Have a great day.